Testing.
Rise, Justices of the Appellate Division, Supreme Court, First Department. Be hear you, all persons having business with the Appellate Division. Draw near, give your attendance, and shall be heard. You may be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. Hope you are all doing well. We have some 9 hours of argument scheduled, so please keep that in mind as I call the calendar. Remember that we have your briefs, we have your record. We're fully familiar with the facts of your case. And so I'll begin with the call of the calendar. People versus Aubrey Carter. Okay. We have a consent on the mandatory surcharge, don't we? This is just and then there's a reduction request? Okay. I'll do 4 and 1 and 4. Eisen versus Catcher. Yes? Where's the appellant? No appellant? Do you wish to submit? Yes. Submit. Okay, thank you very much. Thank you both. Alexander H. Submit. Marinek versus Bohemian Brethren. Submit. Hirsch versus Pashman Stein Walder. Respondent? Do you wish to submit? There's no respondent here. I'll give you 2 minutes. 2 and a submission. People versus Lawrence Rhodes. Submit. People versus Eric Lima. 5 and 1 and 5, thank you. Pacific Alliance versus Juan.
Appellate, Your Honor, request 62.
5 and 1 and 5.
Thank you.
You're welcome. Andreas versus 186 Tenants Corp. Andreas. Would you just speak up a bit, please?
We request 5 minutes for presentation, 5 minutes.
Is there a respondent? Oh, sorry, I didn't see you. Okay, 5, 1, and 5. People versus Jonathan Angulo, and People versus Jonathan Alvarado on Angulo.
Angulo, Your Honor, we request
7, 7 and 2. Who's the respondent on Angulo? Okay, and then we have on Alvarado, so 2 different attorneys, yes?
Yes, Your Honor. On behalf of Mr. Alvarado, we request 7 and 2.
Okay.
I request 7 as well.
Okay. I'll do 5 and 2 and 5 and 2. 5 and 2 and 5. 5 and 2 and 5. Okay. BDC Finance versus Barclays Bank.
Your Honor, on behalf of counsel, request 63. And the respondent, request
6, 2, and 6. People versus Edward Jones. Submission. Lanza versus BHNV Realty Corp. 5, 1, and 5. Michelle versus Michelle. I'm sorry.
Wait.
No, let me finish. I'm sorry, I did, but I'm going back for Lanza versus BHNV on the Rite Aid case. Go ahead.
Yes, on behalf of Brady, Your Honor, we're requesting 5 minutes of argument, 1 minute for rebuttal.
And the others requested 5 and 1 and 5. Is that right?
Yes, sir.
5 and 1 and 5 and 1 and 5. Okay. All right. Thank you. Michelle versus Michelle. Are you the appellant or the respondent? There's no appellant? Is there an appellant? Do you wish to, I don't see, did you see your opposing counsel? Okay, well, it's the calendar call. I don't see anyone. Do you wish to submit? I'll give you 2 minutes. And Toke versus 11 West, 42nd. 5 and 1 and 4. New York Healthcare versus City of New York. Submission. Dickerson versus New York State Division of Licensing. How much time would you like, sir? Okay, and counsel respondent? Okay, I'll do 4, 1, and 4. 4 minutes, 1 for rebuttal, Mr. Reverend Dickerson, and the state 4. People versus Harry Williams. Submitted. Machester Villas versus Eli Development. 4 and 1 and 4. Polaris Venture versus AD Venture Capital.
Your Honor, appellant request 7 and 2.
7, 2, and 7. First case for argument is People versus Aubrey Carter.
Good afternoon, Your Honors. May I begin?
Yes, you may.
Brian First, Center for Appellate Litigation for Aubrey Carter. May it please the court. Aubrey Carter committed the instant offense at just 20 years old, and he has repeatedly acknowledged that he must face the consequences of his actions. But 14 years is excessive given Aubrey's youth, his potential for rehabilitation, and his contributions to his community.
Should we deal with the waiver first, counsel?
Yes, Your Honor. So the waiver in this case is invalid because the court told Aubrey that by going to trial, he was losing his right to appeal. It's as simple as that.
But I'm looking at the transcript on page, how do you deal with page 7, line 22? Do you understand that notwithstanding the waiver of appeal, there are certain rights that you always retain? You retain the right to challenge a constitutional speedy trial violation, and then she goes on. And then, of course, there's the written waiver, too.
Yes, Your Honor, but the written waiver cannot cure an on-the-record defect of this magnitude. The court, just like in Moyet and in Lopez, the court told Aubrey that by going to trial, he was losing his right to appeal. The only difference is in those cases, the court told the defendants that by pleading guilty, they were losing the right to appeal. Here, the court said by not going to trial, Aubrey was losing his right to appeal, but they're the same thing. Defendants only have two choices, plead guilty or go to trial.
What about the passage that I just quoted, though?
Excuse me, could you repeat that, Your Honor?
I'm sorry, I know the mask. What about the passage I just quoted, where she said you do retain certain appeals rights?
Yes, Your Honor. Well, I mean that, but I don't believe that can correct this error that the court the error in the court's colloquy, because, the court is talking to a 20-year-old who has never been before a criminal court before. And we have to look, and when we're deciding whether an appeal waiver is knowing and voluntary, we have to consider the circumstances of the defendant. And here we have a 20-year-old, he's never been in criminal court before. He's given a one-day exploding offer, take it or leave it, and he accepts the deal. But based on this record, you cannot say that this waiver is knowing and voluntary.
Well, counsel, certainly the court didn't say take it or leave it. The court first explained the trial rights he was waiving, and that as a condition of the plea, that he was also waiving his right to appeal. And then defendant had indicated that he discussed the plea with his counsel, he reviewed the written waiver of appeal, and certainly that indicated that the right to appeal was separate and distinct, and that he was also waiving the review of his sentence.
Well, Your Honor, the fact that the court went into those forfeiture rights immediately before the appeal waiver just underscores the point that the court was blending the forfeiture rights and the waiver rights. The court says to him, by pleading guilty, you forfeit all these rights. In addition, by not going to trial, you also lose the right to appeal. So even if the court did in some ways give some clarifying information, just that information alone with a defendant in Aubrey's position could not be expected to understand that he maintained the right to appeal even by pleading guilty.
Counsel, before your time runs out, I wonder if you could address what you hope to maybe for us to look at as the excessive sentence claim, and why you think that's something we should look at in the interest of justice in this case.
Yes, Your Honor. I think that the court should look at this for two reasons. First, the equities in this case. And the equities in this case suggest that Aubrey, since he's 15 years old, he's somebody that was overcoming tremendous personal obstacles and at the same time lifting up others in his community. He did this at the Youth Link program, where he was selected as an intern at the Police Athletic League, where they selected him to be an example for other students. And he did this, and when he went to college, he got into ROTC. He wanted to be a military officer, and I see that my time is up. If you'll allow me another minute to finish, or I can wrap up.
I'll give you 30 seconds.
Okay, Your Honor. So just
finish up on rebuttal after that.
We just know that this is Aubrey's true character, who's somebody that tries to lift up others. And we know this because after he got incarcerated, that's exactly what he did. He enrolled in every program available to him, and his case manager wrote to the court in support of Aubrey and saying he didn't just succeed individually in all these programs, but he assisted others in their learning. And I'll reserve the rest of my time for rebuttal. Thank you.
Thank you.
Your Honors, and may it please the Court, Anna Notchik for the people. Your Honors, defendant's excessive sentence claim is barred by his valid waiver of appeal and in any event is unavailing given the serious nature of his crimes. Turning first to defendant's waiver of appeal, at the plea proceeding, Justice Bibbin accurately separated the rights defendant was giving up by pleading guilty and the rights defendant was giving up by signing a valid waiver of appeal. When describing the rights defendant was giving up, Justice Bibbin explained that in addition to the rights that he was giving up by pleading guilty, defendant was also giving up the right to appeal conviction had he gone to trial. Further, Justice Bibbin explained that defendant was retaining some rights in the appeal waiver. And also, any ambiguities or imprecisions in the oral colloquy were accurately supplemented by the written waiver. Further, even if this court were to decide this case on the merits, it is clear that defendant is not deserving of a sentence reduction given the serious nature of his crimes. Defendant has admitted to attempting to kill 3 people. Defendant, the day of the shooting, posted on Facebook that he wanted to eat at someone's funeral, and a co-defendant responded that they should kill someone and eat at their funeral. Therefore, given the serious nature of defendant's crimes, his sentence should not be reduced in the interest of justice. And if there are no further questions, I rest on my brief.
Thank you.
Just briefly, Your Honor, I would just like to address the notion in the people's brief that Aubrey's sentence was lenient because his exposure here was 25 to life. I believe that's incorrect because Aubrey Carter should have never been facing 25 to life. Initially, he should never have been charged with first-degree conspiracy, and he wasn't initially. If you looked at the first indictment in this case, Aubrey was not charged with first-degree conspiracy, but 5 people were. So the idea that the police later discovered that some person under 16 was involved in the crime is just not accurate, and that's why they knew that someone under 16 was involved, but decided not to charge Aubrey with first-degree conspiracy. And this is the correct decision because Aubrey had no involvement whatsoever at any point with anybody under 16. It's only after Aubrey rejected the people's 14-year deal and defense counsel's on vacation that a new indictment is filed alleging first-degree conspiracy. And if you look at the facts, there's not a single new factual allegation leveled against Aubrey in this new indictment. It's copy-pasted directly. There's only all there is a factual allegation against a minor named Brandon Gonzalez of a shooting that he committed 7 months after Aubrey is incarcerated. I see my time is up. Thank you.
Thank you. Thank you both. Hirsch versus Pashman Steinwalder.
Good afternoon, Your Honors. My name is Cheryl Corman, and I represent the defendant, Pashman Stein, in connection with this matter. The plaintiff can never sustain his burden of proving proximately caused damages based upon the fact that Kemper was not timely sued for his loss. Plaintiff's required to show not only that he lost the ability to sue, but also that he would have recovered. Here, pursuant to the policy, residency was required in order to recover for the damages. It clearly defined the unit as a unit where you reside. The unit was purchased in 2007, and it is undisputed that the plaintiff never moved into the unit. So,
Didn't he argue kind of consistently that it was, that the policy was ambiguous as to whether it was just a residence unit for him ultimately to be residing in, or whether he actually physically had to be residing there, or someone didn't have to be residing there?
well, pursuant to the case law, when you look at this clear residency language where it specifically says the unit where you reside, the individual is required to actually reside there. And we have a general cases that are cited in the brief that clearly stand for that proposition. And I would also argue that in terms of any argument in terms of residency, it wasn't really raised by the plaintiff in connection with his underlying motion papers. Really what he was focused on is just the failure to timely sue. And that really was the focus. It never really hit the but-for analysis, which was necessary and actually dispositive here. I'd just quickly like to point out that in addition to the residency requirements, there were other issues that were not addressed and entirely ignored, including the fact that the water damage was in fact the condo's obligation to fix pursuant to the clear terms of the condo offering plan, and that any coverage by Kemper would have been excess over the coverage provided by the condo unit, and there's no indication that that coverage would have been not enough. And just also, under the clear terms of the policy, any
Thank you,
damage-
counsel.
Can I just finish this one thought, please, Your Honor?
You can finish your sentence, but there's nobody arguing in opposition to you.
Any damage should have been limited to the $10,000 sublimit contained in the policy, which is clearly set forth in the
Thank you.
endorsement. Thank you.
People versus Eric Lima.
Good afternoon. Margaret Knight from the Office of the Appellate Defender on behalf of Eric Lima. Mr. Lima had no criminal record when he was charged with a Class A2 sex crime. The allegations occurred years after the alleged abuse in the context of a heated custody dispute. There was no physical evidence that the abuse...
Counsel, what are the allegations that the lawyer pressured Mr. Lima in this case? During the allocution, he didn't say a word. And what are the allegations that was raised?
Mr. Lima said that his attorney told him to plead guilty even if he were innocent, that the attorney did not want to talk about the actual defenses, but only wanted to talk to him about the plea in the case, and also that his attorney had disputes with his wife and that there was a breakdown in communications. So all of that was...
And which of those did Mr. Lima express to the judge during his allocution?
He did not raise those in his allocution. However, the allocution was monosyllabic, bare bones, and there was a pause. In fact, the court asked if he was on drugs. He said no. Have you had a full opportunity to discuss this with your attorney? Yes, you have. The court asked. Then there's a pause. There's no answer. And the court then proceeds to ask him again if he was on drugs. So while it's not present in the allocution, that's just one, we're not saying that the allocution is...
So counsel, weren't there 9 court appearances before the allocution?
There were a number of court appearances,
9?
yes.
And during any of those court appearances, did the defendant ever raise any issue with respect to his counsel?
He did not.
And how long did his counsel represent him?
I'm sorry.
How long did counsel represent him?
I believe the charges were made in 2016, and he pled in 2017. So over a year.
A little bit less than 2 years, right? 20 months. So the entire 20 months, 9 court appearances, and his allocution never says a word.
In the motion to withdraw the plea, he did include a conceitedly unsent letter to the court raising expressions of doubt about his attorney. But his problems with his attorney were only one portion of this complementary challenge that raised also his innocence in this case. And this was a case where Mr. Lima said he was innocent for, as Your Honor said, many months, actually many years, because there was an ACS case that started in 2012. The complainant waited 2 years to make any allegations of misconduct. In 2014, he was not indicted until 2016. For many years, he asserted his innocence and had a momentary lapse before the plea where he pled guilty, and then within a week he was not cooperating with probation at great
can I ask
personal
you,
risk.
when you say he had a minute, it was a month, correct? He had a plea offer and he had a month before he actually pled.
Well, there was no...
I just want to first, is that right?
He had a month to
He had a month
think
to
about
decide during that period of time between when he actually got the offer and when he actually pled. He had a full month to decide whether or not to plead. And again, said nothing about his lawyer then, correct?
The court conducted no inquiry of his attorney. We don't... Yeah.
Did he ever say to anyone during that month, after he got the plea offer and before he pled, did he make any indication to the court that he was not happy with his attorney?
Well, there were no court appearances in that month. I'm sorry. All I can say is, yes, he did have a month where the offer of 8 years was on the table. We don't know because the court conducted no inquiry of his attorney when exactly he decided to plead guilty, but we do know that within a week after the guilty plea, he was supposed to go to probation. He did not go to probation. He did not cooperate with probation, and that by itself could have given him a sentence of 25 years with 20 years of post-release supervision. There were also many reasons to doubt the complainant's account. This is an unusual case where the complainant made at least 4 unfounded complaints of abuse and sexual misconduct. She said that Mr. Lima had abused her during a supervised ACS office visit.
Thank you.
Thank you.
Good afternoon, may it please the court. Michael Yetter for the people. The court properly exercised its discretion denying defendants' written plea withdrawal motion in this case. I think some of the points Your Honors made, defendant was extended the plea offer on November 1st, 2017, and in the ensuing month, there's no indication that he did anything to suggest that he was not interested in the plea offer. And then the plea proceeding itself, of course, confirms that he made a no involuntary intelligent plea. I think the judge acted entirely appropriately in relying on the thorough plea allocution in this case. And defendants has both his claim of actual innocence and his claim of attorney coercion are just not supported by the record. And in fact, they're contradicted by his representations at the plea allocution. If Your Honors have no further questions, I'd ask you to affirm.
Defendant's main argument is that he should have been given a hearing. He wasn't given a hearing. What would have been the downside of doing a hearing?
Well, I don't know if there would have been a specific downside, Your Honor. The problem here was the allegations made in both of the filings defendant made in this case were insufficient to entitle him to a hearing. There was no factual dispute. I suppose defendant could have been afforded the opportunity to speak his mind further, but just the allegations were patently insufficient, and there was good reasons to deny them in the face of the uncontradicted representations he made at the plea proceeding that he made under oath. Thank you.
This is a case where the court should have at the very least conducted a hearing. Mr. Lima was adamant in his claims of innocence. He supported them with, throughout the course of the proceedings, 4 instances, as I said, where the complainant made false allegations of sexual misconduct and other abuse other types of abuse against the foster care mother and the foster care mother's sister, against Mr. Lima's own brother. She said that Mr. Lima had abused her during a supervised visit at an ACS office, and also claimed that he abused her when her aunt and uncle were present, which the family court apparently found unfounded. So given that Mr. Lima had no criminal record, given that he was facing the most serious of charges, given his adamant proclamations of his innocence, given that no prejudice was ever alleged by the prosecution, given that he at great personal risk stopped cooperating with probation and still at great personal risk is willing to face a life sentence, at the very least, there should have been a hearing into his conversations with his attorney and his claims of innocence. Thank you, Your Honors.
Thank you. Thank you both. Pacific Alliance versus Juan. Justice Kapnick is recused from this case.
Good afternoon, Your Honors. May it please the court, Ira Matetsky from Ganford Shore for the appellant, Mr. Kwok. The judgment in this
Counsel,
case...
if I might, among other things, the defendant, Kwok, submitted 4 documents to change venue, and and then, in addition, turned over keys for an apartment, presumably to satisfy the guarantee. So I'm curious as to then, when he realized that these documents, for example, these 4 documents that he added to the motion, or any of the other statements he made, that these documents were correct, or the gesture of turning over the apartments that suggested he was actually the guarantee. I'm trying to understand when he realized that all those documents were forgeries.
Well, the first time he came face to face with the documents that's reflected in the record was his deposition. Everything else was on paper, dealing, through attorneys for a non-English speaking, certainly non-English reading person. At his deposition, he had shown the 2011 personal guarantee, which is the basis for the judgment, and a number of other documents, and he unequivocally says, no, that is not my signature. I did not sign these documents. The court is probably familiar with cases where a party at his deposition testifies one way, and then later on an attorney tries to clean up the case by putting in an inconsistent affidavit, and the court says, no, the party is bound by the deposition testimony. Here, the deposition testimony is unequivocal that the documents were not authentic, and that should at least entitle Mr. Kwok not necessarily to prevail on that issue, but to be heard on that issue. What the judge below did here was to say that I will not listen to Mr. Kwok, I will not hear him at all on this issue by invoking judicial estoppel. And as a matter of
Counsel, go ahead. On the FNC motion, the foreign nonconvenience motion, he offered the U affidavit, correct?
his attorneys offered the U affidavit, that's
Okay.
correct, which put in
And
copies.
there
of
was
some
a subsidiary finding by the trial judge, and I think also by our court, that Hong Kong law applies because of those documents that were offered in the U affidavit.
I apologize, Your Honor, I couldn't hear
That
that.
Hong Kong law applies to this case based on the documents provided by Ms. Yu.
I don't think that the judge actually got into the question of choice of law at all in the context of the forum non. He talked about where the transactions took place, for example, and where the parties were located at a given time. But in any event,
But that was
whatever
part of the argument for why the case should be tried in Hong Kong, correct?
that was one of the points that was made in Mr. Kwok's motion. I don't know that it's one of the points that the judge relied upon in granting the motion, but most importantly, this court reversed. And once this court and held that the case should be heard here, and the case has been heard here. So in no sense is Mr.
We also
Kwok,
said that the, quote, the fact that Hong Kong law governs the instant dispute pursuant to those documents, ... Is that a finding by this court, or are we upholding a finding of Justice Ostrager?
no, but this court reversed the forum nonconvenience.
I'm talking about the choice of law question. In other words, did Mr. Kwok benefit from a determination that Hong Kong law applies in this case?
I don't think he did, because this court held that that the case would be heard here. The motion was a forum nonconvenience motion. Judge, did you? This was a forum nonconvenience motion. This court reversed and said the case is staying here, and the case has stayed here for 3 years and resulted in the judgment we're appealing from. So in no sense did Mr. Kwok...
Wait a second. Did he ask for Hong Kong law to be applied or New York law to be applied?
He asked that the New York State court system not be applying any law
No,
at
I'm
all.
talking about not choice of forum, choice of law. What law did he ask the court to apply?
In the motion, he argued, among many other things, that Hong Kong law would apply.
Okay, so on what basis did he ask for Hong Kong law to apply? Because clearly there was a section in the agreement.
That's correct.
Right?
The
So
argument
he
was...
relied on that section of that agreement, which he is now saying is a forgery, correct?
That is exactly correct.
So he says to the court, apply not New York law, but Hong Kong law based on this document that I attached to my motion. The court says, okay, you're right. We're going to apply not New York law, not Swiss law, not UK law, Hong Kong law based on that document. And now he says, never mind, that document was a forgery?
That's exactly correct.
And you don't think he got any benefit from using that document to ask the court to apply Hong Kong rather than any other law in the world?
If I may finish answering that question, the answer is he got absolutely no benefit because this court ruled that notwithstanding all the arguments he made and all the documents that were put in by his attorneys, this court ruled the forum nonconvenience motion is a loser.
But did not rule that New York law applied, right? This court ruled that Hong Kong law applied, correct?
I don't recall whether this court spoke to the question of choice of law at all. This court said the case is staying here. Mr. Kwok did not prevail on that motion. I've won in the cases in this court, and I've lost cases in this court, and I can certainly tell when I've prevailed and when I haven't prevailed. Mr. Kwok did not prevail, and it is clear from 40 years of this court's precedent, the Potmos case is the most recent, that prevailing parties, that having prevailed, having obtained a judgment or an order in your favor is the indispensable element.
So you are saying that there is not a finding anywhere that Hong Kong law applies to this case?
There is a finding that Hong Kong law applies to this case, but there is not a finding.
What is the basis of that finding? Who asked for it, and what's the basis for it?
In the summary judgment motion, my adversary asked for it. The forum non-motion was ancient history by that point.
I'm just asking you, what was the basis of finding that Hong Kong law applies?
In the initial forum non-convenience motion, the argument was made that Hong Kong law applied.
Who made the argument?
I think both sides made that argument.
Including your client.
On the forum non-convenience motion, on which he was not the prevailing party.
I understand that he didn't win the forum non-part of the motion. But what I am asking you is, did he argue in that motion that Hong Kong law applies? And has the court since then applied Hong Kong law?
I don't think the fact that the court applied Hong Kong law on summary.
Counsel, if you could ask the question directly or else finish it on rebuttal.
The answer is that those two things happened, but I don't think that one caused the other.
Okay.
Thank you.
Thank you, Your Honor. May it please the court, Anton Medlinsky for Pacific Alliance. Just to answer the question, it's the second sentence of the trial court's forum non-decision says that the transaction is governed by Hong Kong law, and then this court says two things. First, it says, this is on appeal, it says that it is true that the agreements at issue in this breach of contract action concern a Chinese real estate development project, and then most of them were negotiated and executed in Hong Kong or China. And then it says the fact that Hong Kong law governs the instant dispute pursuant to the choice of law provisions in the agreements is not dispositive. It is true that the appellate court then found that as a matter of law, despite the fact that these agreements provided for Hong Kong law, Mr. Kwok was wrong that required dismissal for forum non-convenience. But that's exactly the same fact pattern as in the Nestor case. The Nestor case is directly on point. There was a reliance on an agreement. Party A won based on that agreement. Then the decision was reversed on appeal. And then Party B came in and said, we want attorney's fees under that agreement. And then the party came back and said, actually, a different agreement applies. And this court said, of course you can't do that. Just because your legal fortunes have changed, you can't now take a different position than the position that you convinced the first court to adopt. And that was in the same proceeding. It was exactly like this case. And of course, that makes perfect sense. It would be one thing if this court had reversed on the ground that the contracts were forgeries. But the court didn't reverse on that ground. It reversed on a ground completely separate from the subsidiary issue that Mr. Kwok got the trial court to accept. And the whole point of the doctrine of forum nonconvenience is to prevent parties from getting a court to accept a factual or a legal position, and then when their legal fortunes change, to get the court to accept a position that's directly
Counsel, what are we supposed to make of Mr. Kwok's statements that the U affidavit was somehow manufactured against him because he is seeking asylum in the United States? He is at odds with the Chinese Communist Party. So he's saying something happened there. What are we to do with it?
I mean, he's saying that, Your Honor, but for the Banco Popular case from the Court of Appeals says that just bald assertions of forgery are not sufficient to create a question of fact at summary judgment. And in any event, it doesn't matter because it's not like Mr. Kwok intervened and said, actually, you shouldn't find that this contract provides for Hong Kong law and thus the case should be dismissed for forum non. He convinced the trial court to actually dismiss this case. Is his argument that he was just lying the whole time and that there was a judgment entered in his favor and against my client based on a contract that he now says is a forgery?
Well, I suppose one can imagine a client relying on his lawyers to make an argument about forum non-conveniens, which is a fairly procedural argument that has certain standards that a layperson is not going to know.
Well, clients are bound by their attorneys as agents all the time. I mean, criminal clients all the time go to prison are even executed based on decisions that their lawyers make. So I don't think that's an argument in his favor. But even if you think there's a problem with forum nonconvenience, how about judicial admissions? I mean, there is a response to our RFAs. We asked, admit that you, Shiny Times, Beijing Pangu, and Pax LP executed a deed of settlement dated April 19th. This is just an example. There are a bunch of these. April 19th, 2013, which, among other things, confirmed that at the time of the original deed of settlement's execution, Shiny Times owed Pax $52 million. And the response after general objections was, Kwok admits only that he, Shiny Times, Beijing Pangu, and Pax executed an agreement dated April 19th, 2013.
And was that sworn? That
Yeah,
those are interrogatory responses or those requests for admission, I'm sorry,
Yeah,
were sworn, correct?
not only that.
By him.
Yes,
And
and
he
not
says,
only that.
I read them and I swear to them, correct?
Right, and on page 499 of the record, there's a verification signed by Mr. Kwok that says, I'm the defendant in this proceeding pursuant to the CPLR. I make this verification of defendant's responses and objections to plaintiff's first set of requests for admission. I am a native Chinese speaker and do not read English. As a result, the foregoing denials, objections, and qualifications were read to me by such and such a person, et cetera, et cetera, et cetera. I don't think they argued that that was a forgery. So that is a clear judicial admission. There's a stipulation in the record about the authenticity of these documents. There are repeated statements in various briefs, not just FNC, about the fact that these documents are not forgeries, and also that he actually complied, with the conditions precedent in the deed of settlement. So it seems to me that if—
Counsel, I just want to go back really quick. You know, the April 2019 stipulation and the cover letter, didn't that only address the admissibility of listed exhibits for the upcoming hearing? That was it.
The admissibility, they objected to the admissibility, but not to the authenticity. It didn't say only for purposes of this hearing. I'm not sure what that would even really mean. I mean, a document's either authentic or not. But in any event, there's plenty of other admissions, including the responses to the RFAs, and there's the totally separate point, independent of both judicial estoppel and judicial admission.
Because I really see it as an informal admission, certainly not a formal one. I mean, there was never a formal admission about authenticity, never.
Oh, sure there was. The RFA that I just read, the question was whether you executed an agreement. And the answer was yes, Kwok admits only that he, Shiny Times, Beijing Pangu, and Pax executed an agreement on, this is an example, April 19th, 2013, which happens to be the date of the 2013 deed of settlement. And their argument there is that we didn't attach the actual contract, but the CPLR says copies of the papers, documents, or photographs shall be served with the request unless copies have already been furnished. And of course, they're the ones that furnished the copies when they filed their motion for forum nonconvenience.
Thank you.
Thank you, Your Honor.
Moving quickly, Your Honors, through a number of points. This court's case law is very clear that prevailing party status is required to invoke judicial estoppel, and that a decision that's been overturned, whether it's in the bankruptcy context or some other context, a decision that's overturned means that if you were once a prevailing party, you are no longer. So there is no judicial estoppel. The Nestor case that counsel cites, frankly, it's just an outlier. It doesn't reference the prevailing party requirement at all. It's a 21-year-old case that's just not consistent with the great weight of this court's jurisprudence. With regard to the alleged admissions, the fact is that that's not the basis on which Judge Ostrager found that Mr. Kwok was prohibited from denying the validity of the documents. We don't believe that there was an admission, certainly that there was a knowing and understanding admission, and the stipulation, as one of your honors indicated, was in the context of a specific hearing about an attachment of property, not on the merits, and counsel for both sides were just trying to simplify the issues for the purpose of that particular hearing. So Mr. Kwok should be entitled to his day in court. It would be it would be for him to present evidence as to whether or not these documents were forged or not. I'm sure that counsel would bring.
Thank you, counsel.
Thank you.
Andreas versus 186 Tenants Corp. Justice Scarpullo is recused.
Good afternoon, Your Honors. John A. Giasilli for the appellants. If it please the court. On behalf of the appellants, Your Honor, I'm arguing that the trial court engaged.
Counsel, your clients were living in Japan, right, for a number of years?
Yes.
And so, and in this case, they complain that there is, leaks and all kinds of things. But where in the lease, where in the document do they have the right to withhold maintenance? This is a small building, and the withholding of maintenance is problematic for the building. On what basis do they withhold that maintenance?
Well, Judge, as of March, or I should say April 1st of 2019, the clients were ready to return from working in Japan, but were unable to do so. But getting back to the withholding of rent, the lease provides that if the apartment is rendered untenable, that.
But you're talking about a warranty of habitability, and there was no hearing, no finding at that point for a warranty of habitability, and is that right?
If it please the court, I was not referring to the warranty of habitability, which is a statutorily implied.
What are you referring to
right,
then?
But rather to the explicit terms of the lease, and under the Granera case in this court.
But the lease speaks to casualty, doesn't it? It doesn't.
I'm sorry,
speak
Judge, it speaks
to casualty. Thank you.
I'm not getting that word.
Casualty. Casualty in section.
It speaks of fire or other casualty.
Well, I don't believe that the kinds of leaks and other issues that they're referring to here are considered casualties in the way that it's used within section, I think it is Article 1, Section 3, or Paragraph 3.
Well, Judge, I would say that under the Granera case, water leaks are a form of casualty previously recognized by this court, and that they originated from sources in common elements of the building and not the fault of any particular tenant, though there are those instances also of radiator leaks, what have you. But the common elements leaks are major contributors to the flood and mold conditions in the unit complained of.
Counsel, they got an insurance settlement from Ms. Cushing's insurer, correct?
Yes, Judge.
That was $900,000, correct?
That is correct.
Why can't that be used to ameliorate, it may not fundamentally fix the leaks, but make the apartment habitable?
Well, 2 points there, Judge. One is that the amount of damages to the apartment are estimated at $2 million, which is more than twice the amount recovered, and there are consequential damages of about $1 million. But addressing that, there are still ongoing leaks, according to our expert in the building. Some have been repaired, but my clients have been unable to engage in repairs because there was major leaks into the building, particularly from the waste stack, which contains raw sewage, which was only fixed in December of 2019, though it had been leaking since we don't know how long before that, but in 2018, the lessor was informed of these leaks by our expert, and that leak was later confirmed by experts provided by insurance companies. So, not to mention the other leaks from roof membranes, roof drain holes, through the wall sleeve air conditioning unit, side window deterioration, facade lintels, et cetera. So I think it's basically undisputed that there was a failure on the part of the lessor to engage in regular care and maintenance of the building, and there was also the failure of the lessor to respond to actual written notice of these conditions over a period of years starting in 2016 and every year thereafter as new reports came in.
Are the plaintiffs still paying, at least into escrow, the monthly maintenance?
Yes, Your Honor.
So that's been satisfied entirely?
Yes, Your Honor.
Have anything else?
Well, I would just add quickly, as long as I have time, that there's also issues in my client's favor of the implied covenant of quiet enjoyment, which has been breached by the lessor, the doctrine of constructive eviction. And my client did have people living in the apartment while they were in Japan. A brother of the wife lived there for a period of years, and then a bookkeeper slash building manager who assisted my client while she was president of the apartment corporation did live there, and that went on until sometime in late 2014.
Thank you.
The apartment was, my time is up. Okay.
Thank you.
Good afternoon. My name is Mark Alonso of Alonso, Andalcar, and Thatcher. I'm here on behalf of the Co-op Corporation, 186 Tenants.
Counsel, your opposing counsel says that the kinds of issues that were, that existed in this building did equal casualties, were casualties. What's your response to that?
The clause in the lease actually says if the apartment is destroyed by fire or otherwise, not casualty. It specifically talks about fire or otherwise. And I believe the lower court correctly interpreted that provision as dealing with a fire destruction or something of that ilk, like when we've seen, unfortunately, a Con Ed explosion and there's
I mean, I agree with you that under certain circumstances, certainly leaks would not be covered. But counsel's explaining a situation where the leaks are from sewage pipes that are making it impossible for his clients to reside in the apartment. And so although it's not a fire, it's a type of thing that makes the apartment
It could be,
uninhabitable.
I would say, if it were the case, but it's not the case. Let me tell you a few reasons why. There were 2 leaks in this building. 2015, upstairs neighbor, an elderly woman, had a radiator leak, nothing she caused.
Is that the case that was settled from the insurance company?
Yes.
Yes. Okay.
That created some damage. They never fixed it. Had they fixed it, you would have had new plaster, and then you would have seen, oh, there's still a leak or not. There is no leak. There have been experts through the apartment. A couple of years ago, another pipe broke, little pipe. The woman upstairs noticed it. There was some damage in her apartment. There was a little bit of leakage into the apartment below, my adversary's clients, but there was no damage because they'd already had bubbling plaster that they never fixed up from the last time. So it wasn't even damaged. The pipe was fixed within a week. Leaking pipes, by nature, are a problem when you have gravity and vertical buildings. These are not single-family homes. It's a brownstone with 4 apartments. The largest shareholding is his client's, 30%, which means the other 3 people are paying all the bills. They're behind in their taxes, and the facts are far more egregious.
Remind me, when did they stop paying the monthly?
2015. And by the way, remember the uninhabitable part? He just said that his brother and his wife were living there, the building manager was living there. That's not uninhabitable. Number 2, the habitability part.
Was there ever a hearing on this? Was there ever an evidentiary hearing, or this has all been done on papers?
You're talking about
the habitability.
On the damage?
On the habitability portion.
No, that's still being defended by insurance company counsel within my proceeding. And if I could take 2 seconds, because the facts are extraordinary.
Well, you have 1 minute and 43 seconds.
There you go. That's
you.
I ask it all. In 2015, his client, the wife, was the president of the building since 1997. She ran the building. The other people were not participatory. 2017, she collected from the upstairs neighbor. But in her capacity as president, she never mentioned that she, in her capacity as tenant shareholder, had sued not just the old lady upstairs, but also the building of which she was the president. Never reported it to the insurance company, never put in a defense. never paid maintenance. 2018, in sorting out, the other shareholders took over the building and found out they were in default by 3 years on this lawsuit. So, and their neighbor had never paid maintenance since 2015. So at that point, we filed an answer. As of right, Mr. Giusilli amended it to state additional claims such as mismanagement by the new board, even though all the mismanagement occurred during his client's tenure. I know there's no cause of action for chutzpah in this court, but there should be for sometimes. That's number one. The warranty of habitability was denied by the judge as a defense the year before, never appealed. At this point, these people have collected $900,000. The whole building is only probably worth $5 or $6 million. Even if Michelangelo was doing the plastering, you couldn't get $2 million worth of work into that apartment.
Thank
The
you.
reality is, this maintenance hampers the building's ability to do anything, including pay taxes.
Thank you.
Thank you. And it's good to be back.
Agree.
If I may, I should reiterate that the clause in the lease that was operative does say for fire or otherwise, not for fire or other casualty, which is common language in some insurance or other leases, but not in this lease, so that an actual catastrophic event like a burst pipe is not necessary, I submit to the court, in order to trigger the operation of the full abatement clause, and that the anti-set-off provision in the lease is self-nullified because of the negligence of the lessor as was previously described. So reading those two provisions together, there should be a full abatement of rent on the showing made. If the showing made is not sufficient, then I would submit that at least there should have been a hearing before the adverse decision was made against my client.
Counsel, can you briefly address your argument regarding the award of attorney's fees? Do you need to
Attorney's
repeat
fees
it?
were awarded to the other side
Yes. Can you
because of a provision in the lease stating that the prevailing party can recover attorney's fees. But I submit that it's premature for that because, one, this should not have been made, and that in any event, a proper assessment of attorney's fees could not be made unless and until the whole action were tried and we saw what were the relative merits or demerits of the respective parties.
You still got your negligence claim, your breach of contract claim, right?
Yes, and shareholders' derivative claims.
Thank you. Thank you both. People versus Jonathan Angulo and People versus Jonathan Alvarado.
Thank you, Your Honors, and may it please the Court. I'm Aaron Brogan with Weil, Gotchel, and Manges, and in association with the Office of the Appellate Defender. I'm here representing Appellant Jonathan Angulo. We argue that Mr. Angulo's convictions were against the weight of the evidence and ask that this Court should reverse. There are two pieces of evidence that were introduced against Mr. Angulo which support his conviction. One being a video, which we argue does not show that Mr. Angulo was acting in concert or in association with any of the participants in the fight.
Mr. Angulo was the one that was standing in the vestibule, keeping the door closed so people couldn't get out.
Your Honor, Mr. Angulo can be seen standing in the vestibule, but I don't think that the video shows him actively holding it closed at any point in time. While he's near the video is a little bit unclear as to exactly what he's doing. There are 2 points at which
There was a lot of testimony that indicated that some of the other gang members tried to get out of the McDonald's, and he was holding the door shut so nobody could get out.
Well, Your Honor, there is testimony that it was difficult to exit the McDonald's, but I believe that this was in no small part because of the crush of people moving towards the door. In particular, later on in the video, when Mr. Barnes testified that he was trying to get out, there are by my view, something like 7 people in the doorway crushing it out. So
wasn't there testimony that he held Mr. Barnes so that somebody else could kick him and assault him?
The state or prosecution in their argument stated that he held Mr. Barnes, but Mr. Barnes never testified that Mr. Angulo held him. He didn't testify that he recognized Mr. Angulo despite being on the stand and being able to do so.
Well, he couldn't identify who it was, but he said he was held by someone, and the video has Mr. Angulo in the vestibule.
Well, Your Honor, when Mr. Barnes first enters the vestibule, he falls on the ground, and this could easily be the point where he suggests that he was held. Mr. Angulo at that point is not close to Mr. Barnes. He's actually behind the door and out of contact with him. And so Mr. Barnes' testimony, not identifying Mr. Angulo, but saying that he was held at some point and that was when he was cut, does not necessarily inculpate Mr. Angulo at all. And so I'd like to emphasize the weakness, then, of Mr. Klassen's testimony, which affiliates Mr. Angulo with the group BDS. So all that Mr. Klassen says about Mr. Angulo is that he is, quote, considered to be BDS. And we submit that this means next to nothing. We should consider what else Mr. Klassen said about BDS and what else he said about Mr. Angulo. Mr. Klassen said that some members of BDS are criminals, yes, but that other members of BDS are musicians. Some of them are fathers who always do the right thing, and some of them have jobs. Mr. Angulo is one of these people. Given the enormity of the weight of this evidence that he was considered BDS in his intent at the time, it's the weakness of the evidence is extremely important. Many members of BDS had nicknames.
Counsel, was Mr. Klassen present when Mr. Alvarado alleged, not Angulo, not your client, the other defendant, handed out the scalpels?
Was Mr. Klassen present?
Yeah, did he observe that? Was that how that testimony came in?
Mr. Klassen was present at that time, yes.
Okay, and was Mr. Angulo present when the scalpels were handed out?
Mr. Klassen testified that Mr. Angulo was present, but I think it's important to remember that it was in the living room, which is the courtyard outside of the building where Mr. Angulo lived, and that Mr. Angulo was only one of among 20 people there.
Oh, but then he was in the McDonald's where the scalpels were used.
He walked into the McDonald's 10 seconds after the active fight participants did. So he was there, but he didn't enter with the members.
It was a 10-second interval for real? I mean, I watched the video, and maybe I wasn't paying attention to the...
Well, it is. It is indeed.
Is that what your estimate is, 10 seconds?
From my count, it's 10 seconds. And so the people who are actively participating in the fight walk in. 10 seconds go by, and then Mr. Angulo walks in, walks it through the vestibule, sees the fight, and backs away. He looks to me surprised. It doesn't look like he walked in with the other people. And in fact, if you look at Klassen's testimony in the lead up to that, Mr. Klassen testifies that he was at Smashies, during which the fight was precipitated by a verbal altercation with 6net. Mr. Angulo wasn't there. Mr. Klassen testifies that he went to the McDonald's and says specifically which individuals were with him. And he says that Mr. Angulo wasn't there.
Are you saying that watching the video, the jury couldn't reasonably have concluded that he was blocking that door?
Your Honor, while it's not the interpretation that we make, what we are suggesting is that the weight of the evidence standard allows
I'm just asking you. I mean, I watched the video. Are you saying that there was no reasonable conclusion, that couldn't have been a reasonable conclusion that the jury made?
We're suggesting that this court should, in its equitable power, consider the video and the other evidence and find that it is not beyond a reasonable doubt that Mr. Angulo committed these crimes because there's not enough evidence that he shared intent with the fight participants.
Thank you.
I had hoped to address sentencing. Could I touch on
You can do that on rebuttal. You have to.
Thank you very much.
Good afternoon, Your Honors, and may it please the Court. John Hughes for the people. The video shows Mr. Angulo very clearly blocking the door in the vestibule of this restaurant, and that's what creates this log jam right at the threshold between the restaurant's dining area and the vestibule that allows Mr. Angulo's accomplices who are wielding these scalpels to just swarm upon all the victims here and hacking at them with the scalpels and everything. You can also see in the video Mr. Angulo throwing punches at some of the victims when they're on their way out. You can also see on the video Mr. Angulo going after one of the victim's barns and kind of grabbing him around the waist, right as Mr. Barnes is trying to make it outside of the vestibule out to the street. So I think the video just very clearly proves that Mr. Angulo was working and acting in concert with all of his scalpel-wielding accomplices in order to carry out this attack.
Counsel, why was the Detective Dunn's testimony allowable? Why was he was allowed to identify Angulo, correct? Oh, no,
That's
he
correct, Your
identified,
Honor,
I'm
yes.
sorry, he recognized Alvarado, pardon me.
Oh, yeah, so there was a different detective
I
who...
withdraw my question, I'm sorry.
Yes, but we can talk about that in a minute.
Counsel, I just want to go back to Clausen because I thought there was testimony that he was able to escape, but that Angulo grabbed him, held him, and then there were other BDS members that slashed him about the body. Was that?
Yes, so Barnes's testimony in terms of when he got cut, in his words, he wasn't entirely clear about when exactly he suffered all of his wounds. And I would point out he had 7 different slashing or stabbing wounds. And so that the first time he was asked about this, he said he thought he was cut in the vestibule or just outside of it, out in the street. We believe at least like some of these wounds, it appears, were definitely when he's on the ground in the vestibule.
Right, but it was Clausen, if I'm pronouncing it correctly, that did testify that it was Angulo that grabbed him and held him while others had slashed. No?
I don't believe actually Clausen testified that specifically. The strongest proof about what Angulo did is definitely on the video. Clausen's testimony was more about what he did, and he did talk about how he saw Alvarado also with the scalpel out and attacking people and things like that.
Okay.
Yes. And then just very briefly to turn to counsel's arguments regarding the background evidence. At the end of the day, the evidence about the fact that Mr. Angulo and Alvarado were members of BDS was very, very important here. And the reason for that is because this attack was a gang attack as a part of a long-standing gang war, provided the motive, it explained all of the relationships between the actors. And even defense counsel was saying that, well, this evidence about Angulo being a member of this gang was really meant next to nothing.
And didn't the judge specifically give a limiting instruction twice, right after that testimony and again during the jury charge, to limit the validity, not the validity, but to limit why what the gang membership testimony could be used can be considered for?
Yes, there are several limiting instructions here. The court stressed that it's not a crime to be a member of a gang. The court also stressed that the mere fact that they might have been in a gang, that did not prove that they were acting in concert with other gang members either. The judge even also said that none of this should be construed as evidence of any kind of criminal propensity. The defense never asked for additional limiting instructions or took issue with how these were worded. And if this court has any other further questions, I'll rest on my brief and ask that you affirm.
Thank you.
Thank you, Your Honors. Now, I'd like to, in response to opposing counsel's argument that the video stand on its own and can establish intent on its own, I'd like to point back to a statement that they made in their response brief, that without the background evidence about BDS, the video, and I'm paraphrasing here because they were talking in slightly different language, but the video would have been bizarre, incomprehensible, and confusing. And I think that stands to the point that Mr. Angulo's intent cannot be clearly determined from the video on its own. Mr. Angulo's actions in the video are completely consistent with somebody who walked into a McDonald's, stayed longer than he should have, but was acting independently.
Look, I mean, the jury got to hear all the testimony and see that video and figure it out. They came to the conclusion that they did. I mean, you're suggesting that there's no way they could.
Well, Your Honor, I would suggest that this court is uniquely empowered in this case to view the video on its own and to have the same access to view it as the jury did. And so, given that, I'd like to touch briefly on the sentencing point. Mr. Angulo was sentenced to 12 years, which we contend is a very long sentence. Even accepting the respondent's view of the events as true, Mr. Angulo had the smallest role of anyone in the events of that night. He didn't start the fight, he didn't enter the McDonald's and fight anyone, and he didn't slash anyone. Proportionality suggests that it's unjust for Mr. Clausen, who by all accounts was a core participant, in the fight to receive only 5 years, while Mr. Angulo is in prison for 12.
Well,
Furthermore,
Mr. Klassen is the person who's cooperating, isn't he?
he is, yes, but nonetheless, the vast gulf in the sentences is unjust. I mean, it's
Frankly, you know, that he testified at great risk, I would imagine, right?
Well, he testified to great personal benefits since he would have been in prison for 25 years, but
Perhaps it would be better to compare his sentence to the other members of the gang as opposed to the cooperator.
well, even in that case, I think it's clear that Mr. Angulo's role was far less than other participants who received similar sentences. All right, I see that my time is up. Thank you, Your Honors.
Thank you, and thank you for volunteering your time, and thank your firm as well. We appreciate your service. And People versus Joseph Alvarado.
Good afternoon. Benjamin Rutkin-Becker on behalf of Joseph Alvarado. There are multiple errors here that require reversal of Mr. Alvarado's convictions, and I would like to mainly discuss the Brady and confrontation errors. But first, Justice Moulton had asked a question about Detective Dunn. Detective Dunn should not have been allowed to identify Mr. Alvarado at trial. At the time of the court's decision, there was no change of appearance, none noted in the record to justify his testimony. During the trial, Xavier Clausen testified only simply that Mr. Alvarado appeared to have lost some weight. That was insufficient to justify the detective's identification. And unlike many cases in which this court might find error but find it to be harmless, here this error was not harmless. The prosecutor essentially attempted to turn Detective Dunn's testimony about a blurry video into expert testimony, something that was clearly improper for him to be testifying to, saying that he was trained to identify faces, that he had essentially extra training that could make him see what clearly was not visible.
Well, Detective Dunn also knew Mr. Alvarado for several years from the neighborhood and testified to that, so he was familiar with him over a period of time.
There was testimony to that effect. Yes, Your Honor.
Isn't that one of the exceptions?
That alone has not been held to be an exception, Your Honor. There has to be some change.
Where there's a relationship, a close relationship, where the person has much more of a basis to be able to identify?
Well, I would take some issue with the much more, but I think if you look at Dunn's testimony, these were actually sporadic encounters over years.
He said he had several long conversations. I mean, that was his testimony. So it wasn't as sporadic as you're suggesting.
Well, I believe he said he saw him 3 or 4 times over a 7-year period, and without any change of appearance. And again, just a blurry video that he's really in no better position to look at than the jury is to identify Mr. Alvarado.
Would the melee or the confusion in the video give any justification to him testifying?
I don't believe it is, Your Honor. I haven't seen any case law suggesting that confusion within a
Just
video.
there were so many people. There's so many people in that sense.
Right, and the prosecution actually created videos that highlighted each individual where they were pretty impressively able to be tracked. And there's just no reason why the detective really could see something that was just at the end of the day unclear with any more clarity than the jury. But I would like to touch on the Brady and Confrontation Clause issues, which require reversal here. In this unusual case, the prosecution and the court were both aware of star witness Xavier Clausen's prior improper love affair with a juror, and they minimized the impeachment value. This information was not only relevant, but critical to Mr. Alvarado's defense. It shed light on Clausen's state of mind at the time of his testimony in this case and his incentive to fully cooperate with the prosecution. It shed light on his relationship with the prosecution, the fact that he had to be hailed out of prison, produced in court, and then the prosecution ended up making legal arguments at the 3:30 hearing in the other case that defended Clausen's relational privacy. And this was a bad act that evidence.
There were timely disclosures about the McGregor trial misconduct, weren't there?
There were not, Your Honor, because to the extent that there were disclosures, I mean, so going to page 208 of the voir dire minutes, the very first thing that's said about this is the court says there was this odd circumstance that I don't think should ever get in front of the jury. And all that the prosecutor discloses, yes, on the one hand, the prosecutor says this happened, but there's an inordinate emphasis placed on the fact that Clausen and this juror never actually connected during deliberations. That was not what was relevant about this. The representations made to counsel indicated that there was nothing exculpatory about this.
But wasn't there an opportunity, I'm sorry, wasn't there an opportunity to go further and get the minutes of McGregor, the McGregor case, and counsel didn't pursue that? I mean, is this even fully preserved in that there were opportunities to get other information and it wasn't pursued?
Well, Your Honor, we might take issue with the fact that counsel didn't get those minutes, but Garcia lays out the standard. That's a case from this court cited in our brief. But this is an inquiry about the prosecution and not what the defense did or didn't do. And the standard also in Laval, which is a case cited in the prosecution's brief, they say that the standard is whether counsel should have known about this information. The standard in this state is actually whether counsel should have known about this information and its exculpatory value. And here, the exculpatory value of the information was minimized and denied. And then a few days after this was first mentioned, the court ruled categorically, I understand in the context of the letters rather than the minutes, but the court ruled categorically that this was not something that should come in front of the jury. And so to fault counsel here and say that this claim wasn't preserved or, as the prosecution argues, was abandoned would really be deflecting from the prosecutor's duties here. And the fact that the court and prosecutor knew of this information and indicated incorrectly that it had no relevance to the defense. I see that my time is up. So if there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you.
Hello again, Your Honors. John Hughes for the people. I'd like to start first with Detective Dunn and his identification of Alvarado. It's pretty well settled that if a witness is more familiar with someone's appearance at the time of a crime, and if, as here, the video is not, crystal clear, it's a typical surveillance video, a little grainy, and also if there's evidence that a defendant's appearance had changed somewhat between the time of the crime and the time of the trial, these are all circumstances that provide a basis for the court to providently exercise its discretion in allowing a witness to identify someone in a video. So this is very different than other cases where a witness might not have had any better reason or any better ability to identify someone in a video as compared to the jury. But this just isn't one of those cases.
Do you want to deal with the last point that defense counsel raised about that's sort of an unusual situation. And
Yes.
Of course, it only pertains to Alvarado, not the other case. So I wondered how you would address some of the claims that he's made there.
Well, in the first place, I think it's kind of puzzling to call this a Brady issue because we disclosed this. It was during voir dire, and we and the court together disclosed to defense counsel that at this prior trial, where this witness, Classen, testified, that a juror at that other trial had reached out to Classen, that they had corresponded, that they had fallen in love, and that furthermore, there was an entire post-conviction motion and hearing held about this topic. Now, the prosecutor noted that while she did not have the minutes from that, she did state that they were publicly available. And she knew this because a reporter had been actually looking for them. And then, Alvarado's attorney in the moment.
They never proceeded to get those minutes? Was that what happened?
I mean, from that point on, it looks like the issue was completely abandoned. Defense counsel never.
Should the minutes have been provided by the people? I mean,
what's that?
Should the minutes have been provided by the people rather than suggesting that the defense should go and get the minutes?
Well, at that time, the prosecutor just didn't even have a copy of them. But I think we provided ample opportunity for the defense to be able to get them, both by making this disclosure. And also, I would note that the trial judge immediately said that he would sign an order so that the defense could obtain these minutes. And so I think,
But that was never pursued. Is that what you're saying?
it never comes up again in the record. So, on this record, it's unclear whether that was just completely abandoned or if defense counsel got the minutes and just didn't decided not to do anything with them. The record's kind of silent as to what actually happened there. And it's important, I would note too, that the New York Daily News published an article about this exact hearing and went into a lot of the details, and this was published months before defendant's trial even happened. So at the end of the day, this is all a matter of public record. And so, the argument that somehow this was suppressed or that we buried this, I think is frankly just puzzling. If the honors don't have any other questions, I'd like to rest on my brief and ask that you affirm. Thank you.
Thank you.
So we are not arguing that the prosecution needed just independently to provide the minutes of the 3:30 hearing to counsel here. What should not have happened with information that the court and prosecution both knew was to minimize its import. Now, that could have been caginess. It could have just been...
If the judge indicated, and I thought I read that he would sign an order to assist you in getting these records if you wanted to, and the record did not include anything after that, did you pursue them? What happened after that, if you know?
It's not in the record whether those minutes were ordered or not. What is in the record is a few days later, the court making a ruling, which effectively was a final ruling, that this information was not relevant to this case. And again...
But you're not talking about the minutes, because
No,
nobody ever you're talking about the letter that the court said it would review in chambers. There was no objection to that, I don't think, on the record that said, no, we absolutely want to see these letters. It's not enough that you just review them in camera.
The ruling was about the letters, but when you combine the initial representations, again, that this had no value, and then later that ruling when these letters were looked at, and the important thing that should not have happened here was the inordinate focus on the fact that Klassen and the juror didn't actually connect during deliberations. As this court has instructed in the McGregor case, yes, that case concerned the juror, but it takes two to tango, and the fact that they didn't actually connect. I mean, Klassen was willing to contact a juror to put the integrity of these proceedings at issue.
But that was known. That was known. That was no secret. That could have been crossed on.
It could not have been crossed on, Your Honor, because the court said that there was no relevance to this information, and just...
But where's the... Go ahead.
The fact that the court asked the prosecution, oh, well, it's just to confirm merely, oh, they didn't actually connect during deliberations, right? And the prosecutor says, yes, that led counsel to believe that there was nothing improper about what Klassen had done, and that's just not the case. This demonstrated his willingness to place his interests above society.
Just to be clear, I see your red light is on, but I just want to be clear. It did come out that Klassen had tried to contact the juror, but did not make the connection. She did not respond, and that they did not speak until after the verdict.
Thank you for asking that question, Your Honor. Yes, because that is actually the critical point.
So let me just, okay, so that's correct.
That did not come out, Your Honor.
Which part didn't come out?
What came out was simply the fact that they did not actually connect during deliberations. It did not come out that Klassen had attempted to connect during deliberations. That's the critical fact here, and that is what was buried. That is why there is a Brady violation here that requires reversal of Mr. Alvarado's conviction. Thank you, Your Honors.
Thank you. Thank you both. BDC Finance versus Barclays Bank.
May it please the court, Gregory Joseph for Appellant BDC. Your Honors, my argument can be summarized in 3 sentences. Liability has been litigated in this case for 13 years. BDC's defenses to damages have never been considered. It is entitled to a trial on damages. We did have a trial. It was limited to liability. Under Justice Branston's scope of trial order, the only question was whether Barclays defaulted. She specifically contemplated that a subsequent trial on damages would ensue on the counterclaims. That's at page 424 of the record, and again at page 438 of the record. That is the trial that we're here to get.
Well, do you have to show that there's some question about Barclays' reasonableness and good faith in its loss calculation first, before you get to damages?
Justice Moulton, I'm sorry, I have to show that.
Do you have to show that Barclays, there's some question about Barclays' reasonableness
Correct.
and good faith in calculating its losses?
Correct. And we have, from the former chair of the ISDA committee that drafted the master agreement, a 108-page opinion and 800 pages of deposition.
Yes, Barclays faults that affidavit. Barclays faults that affidavit for not identifying particular lowball bids that were included in the BWIC.
Your Honor, they can take attacks in any part of this opinion, but she had 4 parts to this opinion, and these are really issues that they're identifying that are issues for the court on the issue of damages. We have put in evidence that there was not a commercially reasonable good faith effort. We've shown, for example, and she testified, that on the issue of the replacement cost on financing, that was $1.5 billion of financing that they were lending at a below market rate, LIBOR plus 50. By the time of the termination, the market was LIBOR plus 250 to 500. They could take that $1.5 billion and they could lend it to others at the higher rate. Account for that.
Are you saying that this is really a battle of the experts almost, and that it's no different than the case of Lehman, where the same expert provided evidence and there was the same, I think, contract or in that
Yes,
case?
Justice Kapnick, that's exactly what
I'm
was.
Justice Renwick. That's Renwick.
I thought
Hard to tell who's
I
speaking.
thought I said Kapnick, I apologize. I know Justice Renwick was actually on the Lehman panel.
I was.
I'm
It's
not
hard to
gonna
tell
try and
who's
explain
speaking.
Lehman to her, but
Yeah, I was speaking. It's okay.
But that is exactly what we've got. She's the same. She's providing an opinion of the same sort that she provided in that case, which was sufficient to create the factual issue that we get a trial on. Otherwise, the Court of Appeals never addressed damages calculations. This court's never addressed
Mr.
it.
Joseph, it seems, to the extent that I was reading Judge Maisley's, the record of the oral argument on summary judgment, it sounds like she felt constrained by either one of our other opinions or the Court of Appeals to not be able to grant your motion. She thought you gave very good arguments, but she was kind of precluded. Now, I looked at our other decisions in our the Court of Appeals decision. It didn't seem like it was precluding that. I mean, I also understand that that a lot of the loans you really aren't disputing. There's just like a limited number, a small percentage that there's some issues raised. Is that correct?
Yes, Your Honor. Let me be clear.
That was Judge Kapnick.
Yes, no, I apologize.
That's
I said
okay.
that one, but I do. What Barclays has done, it's seeking a few $1 million, but it had to offset $305 million of our money that was sitting there. Right? And we're not disputing most of those loans, but we're saying for $125 million of excess, that it's just wrong, and we should be able to be heard on $125 million. And it's never been considered. Your Honors, there are 4 fact issues she's identified. They can take issues with each one, Justice Moulton. I'm not going to dispute that they can take issues, but it's not for this court to decide it. You know, a sufficient basis has been prepared. That we would say that this is the most esteemed expert in the area. They would say that's fine. The court can make that decision. But it's not appropriate that we're denied the opportunity to be heard on a case where we're really dealing with over $100 million of value.
So, counsel, how do you think that your expert shows bad faith as opposed to just a difference of valuation? That's really the critical issue here, because we see lots of experts that fight with each other over valuation, but that's not what your agreement says. Your agreement doesn't allow you to take issue with someone else's evaluation. You have to show bad faith.
Your Honor, we have to show either commercial unreasonableness or bad faith.
What does the document actually say? It says that you have,
I'll read it. I'll read it. This is from the Master Agreement, Section 14. Loss means, with respect to this agreement, one or more terminated transactions, as the case may be, of an amount that the party reasonably determines in good faith.
Reasonably determines. That means you have to show either it's unreasonable or bad faith, right?
Correct, Your Honor.
So what? We have two experts that disagree with each other. How does that become unreasonable?
Well, Your Honor, we should be allowed to put in the evidence to show the bad faith, but among other things, they were taking values below their own marks, so that they're taking values and charging us less than they're charging others. Their marks
Didn't
for the same
they give you a
loans.
credit for that?
I'm sorry, Your Honor?
Didn't you get a credit in terms of how much they could have gotten out on the market? Didn't they give you a $1.8 million credit?
Your Honor, I apologize with the mass.
Okay, never mind, doesn't matter.
I'm sorry.
I just want to know, what evidence have you put in to meet your initial burden that their evaluation was unreasonable or in bad faith, not just different from yours?
Correct. A 108-page opinion and 800 pages of deposition testimony by the former chair of the committee that wrote the agreement.
Not only saying that the methodology was not the correct one, but that it was unreasonable, specifically unreasonable.
Commercially unreasonable and not in good faith.
Oh, okay.
Right. Thank you, Your Honor.
Thank you.
If it may please the court, Jeff Scott, Sullivan and Cromwell for Barclays Bank, the respondent. BDC's position here misunderstands the law that applies to this case. This is not a common law breach of contract case where differing opinions of experts create a contested issue of fact. This is a special case. It's a narrow case. It's a case that applies to ISDAs. And BDC doesn't actually dispute this, but when you deal with an ISDA,
Counsel, how do you distinguish Lehman Brothers then? Because literally Lehman Brothers is right on point.
And it was an ISDA.
So the Lehman Brothers is easy to distinguish, Your Honor. The Lehman Brothers decision out of this court said it was simply affirming the trial court under the circumstances. And when you look at the trial court's decision, the trial court found what you need to find that there's actually a contestable issue of fact under ISDA. There was evidence in that case that there was a customary and standard practice for valuing the assets there, and the non-defaulting party admitted it didn't follow that customary practice.
But the standard in our, I know it was a very short decision in Lehman Brothers, said whether the loss calculation was reasonable and in good faith as required by the agreements. So it was, I mean, those were the determinations. He's saying we've put in enough here that's at least raises a question of fact as to whether it was reasonable. The judge in that case did feel that their summary judgment was inappropriate and that had to go on to a trial, which is all that they're asking for here.
Your Honor, no one disputes the fact that the party who's doing the calculations is entitled to deference. Deference means yielding to the opinion of another. So if you have only two valuations, two differing valuations, that's not enough. You have to show commercial reasonableness, unreasonableness, or bad faith.
Well, didn't that expert affidavit say this is commercially unreasonable?
No, in fact, their expert, Leslie Rawl, agreed that the bids wanted in competition was commercially reasonable. So when
as a general matter, but not in the implementation in this case. That's how I understood her statement to be.
No, with respect to the no-bid loans and the low-bid loans in this case, all Leslie Rawl did was create her own decision tree, which was an alternative methodology. And based on that alternative methodology, she said, I come up with a different higher value. So all she does really is come up with a different valuation. And that's clearly under the Lehman decision from the federal court, from the SDNY, and the trial court's decision, which you affirmed. It wasn't enough to create a contestable issue of fact. And it's important for this court to distinguish between common law breach of contract cases and between ISDA cases, because we have right now over $1 trillion in notional value of assets trading with respect to derivative transactions. And this, the ISDA was written in such a way to have predictability and stability in
Wait a
termination
second.
calculation.
Counsel, didn't she specifically say that the discount rate of 23.33 points was unreasonable?
She said it was
Commercially
unreasonable,
unreasonable.
but she did not say, Your Honor, that it was inconsistent with industry standard, and that's how you demonstrate commercial unreasonabableness.
I thought she said that it didn't.
We can pick apart one word from another, but she did say it was commercially unreasonable. Now, you might have an expert that disagrees with that, but the only question here is, do we need to have a trial on that issue?
You don't need to have a trial on that issue, because in order to show, as we cite to the UCC, what does commercial unreasonableness mean? It means it's inconsistent with industry standard practice.
Yes, and didn't the experts and didn't BDC contend that the methodology was not in line with standard industry practice? That's exactly what they were claiming.
No, the expert here, Ms. Rawl, noted that the BWIC was done consistent with commercial standard, and she pointed to no evidence that the linear regression that Barclays used was inconsistent with industry standard.
She said
I
that
thought she said that. Go ahead.
No, I'm not sure that's accurate, because she says the BWIC is commercially reasonable. There was an objection to the way it was implemented, and also she objected to the process used for loans which didn't obtain a bid.
Right, for the loans that had no bid, Barclays used the linear regression, which applied a discount of 23.22. She herself did not challenge any loans that had a discount of 20 points, confirming the reasonableness of Barclays using the 23.22. For those loans, the market valued them at 0, but Barclays did not apply 0 to them. Barclays used a linear regression, and Ms. Rawl doesn't show that that method that Barclays used is inconsistent with industry standard. That's how you show a commercially unreasonable behavior. And if you look at the trial court decision, I'll tell you exactly what it says. It says that the court held that there was a triable issue as to the reasonableness of the non-defaulting party's calculation because evidence was submitted that there may be a uniform or highly consistent practice of calculating loss in a particular manner under similar circumstances, and the non-defaulting party deviated from that practice. Here, there is no such evidence. Ms. Rawl does not show that Barclays departed from industry custom and usage and standard practices, and thus they fail, and this court should affirm the trial court's decision.
Thank you.
And end this 13-year litigation. Thank you.
All right, counsel, I'm going to ask you straight up, what does your expert say specifically is unreasonable or outside of commercial practice?
All right, first, with respect to replacement funding, Barclays was lending $1.5 billion to BDC at a below market rate once the financial crisis hit. The moment that that happened, it terminated the transaction, it had to account for its gain. Its gain is measured as an industry practice by what it could lend that money to others on. That's a $37 million issue. Second, she said there's a $74 million issue with excessive discounts to assets that either got no bid or low bid. And by low bid, it's not just arbitrary, it's below their marks.
I'm not saying that she disagreed. I'm saying what did she say was unreasonable?
These four things. That's the second one that she said. The third one, she said it was unreasonable for them to delay a week in a dramatically falling market to calculate its loss. And that's another $17 million. And there's a miscellaneous category of about $1.5 million for some others. But all of these are focused on industry practice, and that is what the standard was that was applied by Justice Friedman in the case that Your Honors affirmed in Lima.
I just want to clarify one other thing, because your co-counsel seemed to indicate that this was not a battle of the experts as in common law. And we're very well aware this is a commercial case. I want to make sure Lehman was a commercial case, and it was the same type of ISDA that was in that case. Is that correct?
Yes, Your Honor, same language.
And it's expert testimony that you presented from Leslie Roll, is that right?
Yes, Your Honor.
Interpret that?
Your Honor's already addressed a number of the things counsel raised. I'll just be very quick. What she said about the BWIC is that it's perfectly appropriate to use it, but she said that, quote, what Barclays did with the BWIC is commercially unreasonable. My light is red. You've been very patient with everybody this afternoon. Thank you very much, Your Honors.
Thank you. Thank you both. Lanza versus BHNV Realty Corp. You may begin.
Good afternoon, Your Honors. May it please the Court, David Goldman representing Rite Aid, defendant, third-party plaintiff appellant in this case. It's respectfully submitted that the lower court incorrectly denied the summary judgment motion of Rite Aid. There's absolutely no evidence here that Rite Aid created a dangerous condition or an actual, I'm sorry.
Your person that testified, Mr. Torres, who was the store manager, I understand, he never saw the glue trap on the floor. He just saw it underneath a piece of furniture?
Correct. The third-party defendant, Rent or Kill, was hired as an exclusive
Correct.
company to perform the pest control at that location, and they were responsible for installing.
No, I know, but
maintaining.
I know that, but and I'm not disputing that, but Mr. Torres, he was called over. Did he actually saw Miss Lanza right after she fell? Am I correct or no?
He did speak to her following the accident.
After she fell.
Right, but he had never seen the trap on the actual floor.
Even right when she fell, he never saw it? I mean, it wasn't there when she said her one foot got stuck to the glue trap and her one shoe came off and both feet were stuck. And it wasn't there when Mr. Torr was talking to her? It disappeared?
That's unclear to me from reading the record, Your Honor. I didn't conduct the depositions, and that actual issue is unclear to me. However, I believe that it's clear that there is absolutely no evidence that this trap was ever on the floor at any time, unless it was there momentarily for moments prior to Ms. Lanza having her accident.
Mr. Torres testified it was the policy to not have the clientele see the traps, which one can understand, correct?
I'm sorry, Your Honor.
Mr. Torres testified that it was not possible to see the traps. They were put underneath the furniture, however, right?
Yes, that is correct, Your Honor.
That would make sense because you wouldn't want your clientele seeing mouse glue traps in your store.
Yeah, we wouldn't want them shopping in a Rite Aid store and seeing traps for mice and things like that. Correct.
Counsel, I just want to go back to Torres, because didn't he also testify that he had walked through the aisles the morning of the incident and throughout the day and didn't observe any glue traps?
Absolutely correct, Your Honor. He would do inspections each evening and each morning. Other employees of the store would also walk through the aisles throughout the day and perform their inspections to see if anything was there, and if anything was there would be picked up. And the plaintiff, Ms. Lanza herself, was working in the store, per her testimony, on regular occasions for months before.
And she was there that particular day for a couple hours.
She was there for, yes, I believe it was between 2 and 3 hours.
I forget, in this case, did Mr. Torres fill out an accident report?
I am not 100% clear on that, Your Honor. I apologize for that.
That's okay. Okay.
But I will say that you are correct that Ms. Lanza was there that day, and she testified she had walked in that specific area prior to the accident. She was there for 2 to 3 hours prior doing her work in the store, and she never observed anything at any time that day or any prior occasion. So in summary, our argument is that there is no evidence of creation whatsoever. It was the third-party defendant, Rent-A-Kill, that would install and maintain these mouse traps. We had nothing to do with that, and there's no actual constructive notice. I see my time is up.
Thank you.
Thank you, Your Honors.
May it please the court, my name is Nicholas Herzler. I represent Rent-A-Kill in this appeal. Your Honors, I submit that there's no evidence that my client did anything to create a hazardous condition by doing exactly what it was hired to do. We put the traps in the drawer, not on the floor. Plaintiff keeps saying in their brief, we put things on the floor. It's not true. The testimony from our witnesses, he put them inside the drawer and clipped them into place, and there was a piece of plywood in between the trap and the floor. He did that, according to his unrebutted testimony, 3 days before this accident. He does what he's supposed to do, exactly what he's hired to do. He does that, and he leaves. That's the testimony. There's no witness that comes and says, we did anything besides that. So I just don't see how there's any evidence of negligence.
Did Mr. Razak say how he put the glue trap elsewhere in the store as opposed to by the greeting cards? In other words, did he ever use, he said he folded it up for the greeting card area and put it in the drawers, correct?
Yes.
How about elsewhere in the store? Did he ever just put down a flat glue trap and put it underneath something?
I don't recall any testimony about that. The service reports indicate that in certain areas, not where this accident happened,
right,
but in other areas of the store, it is possible that traps were put, on the floor underneath the gondolas. Again, where you don't want customers seeing this, so it's going to be, out of sight. And that was.
So are you suggesting that we're just supposed to completely discount the plaintiff's testimony that her feet were both got stuck on a glue trap, which I saw pictures of in the record, that I think that she identified. So there must have been a glue trap that she had, and that's what she testified happened. So we just supposed to say, oh, she was lying, there was no glue trap, and she just fell because she tripped over her feet, or what?
No, absolutely. We're assuming that plaintiff's testimony is absolutely true for the purposes of summary judgment. But our point is we put them in a drawer 3 days before her accident. At some point, yes, assuming her testimony is true, at some point, it ended up on the floor underneath the gondola where she was. But what we're saying is for 3 days, we're not there. It's not our store. We're not in control of the place. We're not maintaining it.
But I mean, did you, in the other eye, I thought that we read some testimony that in certain areas they would put it underneath the displays, whatever. In this particular greeting card area, they were folded up and put in the drawers. Couldn't one have gotten, been kicked mistakenly from one aisle to another and gotten there and she fell on it? I'm not saying that makes you responsible or not. I'm saying, is that, that could have happened? I mean, because she said she fell on it. How it got there, I mean, I don't think any of us are ever going to figure that out.
We can only speculate as to how the trap got where it was. But my point is we did nothing to create a hazard because we put it where it was supposed to be. So we can only speculate and say that maybe some other person, and there are hundreds of people had access to this, a busy Manhattan pharmacy. You could have all kinds of customers and vendors in there all the time. However, anybody, moved that trap from where it was properly placed to where it ended up, we can only speculate. But we did not, the evidence here is that we did not create a hazardous condition or have a notice of a hazardous condition.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Eric Gerstenfeld for Respondent Anna Lanza in this case. Your Honors, there's plenty of evidence in the record that establishes that Ms. Lanza stepped on this glue trap, fell on this glue trap. Mr. Torrey was immediately called to the scene where she fell. He testified under oath that he saw the glue trap. At that point, after the accident.
Did he say that he saw the glue trap attached to her foot, or did he say it was underneath the gondola?
He said when he saw it after the accident, it was under the gondola.
So he never saw it attached to her foot?
I'm sorry?
So he never saw it attached to her foot?
No, she testified that her shoe was still attached to the glue trap. and that she had come out of her shoe, and that's what caused her to fall or lose her balance. But the defendant didn't see, according to Mr. Torrey, he admitted that he saw the glue trap after the accident.
No, but we got to talk about actual or constructive notice, though, don't we, with respect to Rite Aid?
Correct, Your Honor.
And cause and create with respect to rent-to-kill?
Correct.
So where's the evidence of either of those things here?
Okay, well, as far as the actual notice, Your Honor, Mr. Torrey testified that he had seen glue traps on the floor. In fact, he testified that he saw glue traps in the greeting aisle on the floor, and that's in the record at page 336. In addition, the contract between Rite Aid and Rent-A-Kill specifically calls for the use of the glue traps in their retail store.
But when you say he said he saw the glue traps on the floor, he meant underneath the gondola, not in the middle of the aisle.
Now, at his deposition, he was specifically asked, did you see the glue trap in the greeting card aisle or under the cabinets? And his answer was yes.
So that's record 330, that's what you're citing?
Yeah, volume
But that's
one,
when he's
page
responding to the
336.
accident. We're talking about like advance notice of this being a problem that could be dangerous to the consumers at Rite Aid.
Okay, well, Your Honors, if you look at the service records 3 days before, well, let's look at the service records from October 4th through October 16th, the 15 days leading up to her accident, which occurred on the 19th. We know that through the service reports that glue traps were applied on 2 of those 3 occasions that Rent-A-Kill was there. On that 16th, on October 16th, 3 days before the accident, the service reports specifically say that 6 glue traps were installed.
But counsel, there's no dispute that there are glue traps. Everyone agrees that there are glue traps. But that doesn't show that Rite Aid had any notice that the glue trap was in the middle of the floor where she could step on it. And in fact, didn't Mr. Torrey testify, I walked through that aisle all during the day. I never saw it, nor did she.
Well, her testimony...
Where is the notice that the glue trap, not that it was in the store, that it was in a place where she would step on it?
Well, we know it was in a place where she could step on it because she stepped on it.
Well, I mean,
and that shouldn't have been there.
She testifies that she stepped on it,
It should not have been there. I mean, testimony from Ramzak was that he never placed them on the floor. Yet
Yeah, but with all of the people they're talking about, it's a store that was open. It wasn't before store hours or after store hours. It was in the middle of all this kind of busyness. So where is the notice with regard to that trap being on the floor? I mean, it could have been that she put her foot too far under the gondola and that she stepped on this thing as it was under the gondola.
Well, I think the service record from the 16th identifies that these 6 glue traps were placed under shelves. There was no notation in that.
The counsel, there would also be records of Rite Aid taking delivery of safflower oil or Gatorade or a bunch of other things that could fall into an aisle and cause someone to slip. But that doesn't give notice to the people at Rite Aid that they have to clean it up. Well, so that's what we're looking for here. What do you got for constructive or actual notice?
Well, Your Honor, well, first of all, we're claiming that it was a created condition, so notice really wouldn't even be a requirement under that theory. It was a created condition because they brought these glue traps
into the store, but not into the aisle. There's no testimony that they were placed in the aisle.
They brought them to the retail floor. It specifically states in the contract that they were authorized to be used. The service agreements, the service reports specifically say they were placed under shelves. And it's undisputed that the use of these glue traps anywhere near where someone can step on them creates a dangerous condition. I think that's undisputed. So, but as to your point as to notice, like I said, Mr. Torrey testified that he had seen these glue traps in the greeting card aisle.
But I guess the concern is he saw them underneath. I still don't know why you call them gondolas. I thought, I didn't know that was what you would call a place where you put greeting cards, but assuming that's what you call it, it was underneath there. It wasn't in the middle of the aisle. So nobody's disputing there were glue traps. We're just trying to figure out how did they get into the aisle, and if they were underneath there, how did they create the condition? And Mr. Torres said he walked around, and other of his employees walked around the store during the day, and nobody saw anything.
Well, I don't think that we're alleging that it was in the middle of the aisle. We're alleging that it was at or near the gondola, which is where she was working. And
But how did her foot get underneath the gondola when she, that's what I don't get.
I don't believe her foot got underneath the gondola. I believe that the
Glue trap moved
at least
up.
that's the question of fact where, that I believe the lower court correctly decided this. It's a question of fact where the placement of this glue trap was at the time when she fell. I think that's specifically what the trial judge wrote in his decision, that the placement of this
Wait
glue
a second, but what is the dispute? She didn't see this glue trap, so she has nothing to say about it. And the only person who has any knowledge of it says he puts it in the drawer. So where's the dispute?
He said he put it in the drawer, yet it was on the floor when she stepped on it.
Yes, but I'm
So-
not saying, but the question, you're saying he created the situation by putting it in a place where she could step on it. She didn't see it, so she has no idea where it was. And the only evidence in the record is that it's in the drawer. You can speculate that somehow it got out of the drawer, but the only record evidence is that it's in the drawer.
I don't believe that's the case because of the fact that she actually stepped on it. She did. I mean, there was no way she could get her foot all the way under the gondola where they might say it may have been
Couldn't
placed.
she have pulled out a card and it might have been stuck to a card and fell to the floor?
No, because Mr. Ramczak testified in the manner that he installed these glue traps, they were clipped in, and they should not have been disturbed by any work or anybody going into the drawer. That was his testimony. So if it had been installed the way he said, that would never have happened. So the only way it could have gotten onto the floor is it was placed there.
Thank you.
Thank you, Your Honor.
Your Honors, I don't want to take up too much of your time, but it's undisputed that no one, including Ms. Lanza, observed the glue trap prior to the accident. It's undisputed there were no prior accidents, and it's undisputed there were no prior complaints made to Rite Aid. The jury would simply just have to speculate as to what caused this glue trap to get on the floor.
And let me just clarify that the manager testified specifically that he went through that aisle in the hours before and didn't see it. So it's not a question of there's no evidence as to whether or not they inspected. He testified to that, correct?
Oh, absolutely, 100%. Their regular inspections were done morning, evening, throughout the day, and counsel for the plaintiff respondent mentions that she was working in the area. I mean, the jury could speculate that the plaintiff caused her own accident, that she pulled out accidentally. Anybody could. It's no different than if something fell from a shelf in a supermarket or a Rite Aid or another pharmacy. It's no different. There's absolutely no notice in this case. Thank you, Your Honors.
Your Honors, I'm going to be very brief. I just took another look at the service reports because plaintiff's counsel mentioned it several times. And when I looked through them, for example, starting at page 866 of the record, they talk about main floors where the traps were supposed to be. So the mention of the floor as far as where the traps were, that's like identifying, they were on the first floor or something like that. It's not indicating that they were placed, on a floor deliberately, especially not when it says inside greeting card shelves. So that's where they needed to be placed. So what we're saying is that we didn't create a condition. We didn't have control over it in the 3 days after we left. And I would ask that the court reverse. Thank you for your attention.
Thank you. Thank you all. Michelle versus Michelle.
Good afternoon, Your Honors. Stacey Cheslowitz for Defendant Respondent. May it please the Court, this appeal is a classic example of how the judicial process can be abused. Although the history of this litigation is very long, the underlying premise is simple. The parties expressly contracted for a college room and board credit to be applied as against the respondent's child support obligation, and both children have received the full benefit of that credit at all times. Indeed, this court has already examined this issue in its 2017 decision after Appellate's first attempt to litigate the room and board credit and affirmed the lower court's holding, finding that the parties' revised stipulation did not modify the divorce judgment's provision regarding the college room and board credit, and that the revised stipulation was completely unambiguous and clear that the only modification made was the $1,000 reduction in child support. The appellant, however, has remained undeterred and has now filed 3 separate motions to litigate the room and board credit. When her attorneys have refused to adopt her arguments, she simply moves on to the next one. She had no qualms about seeking relief from this court, even though she did not comply with the order in the decision appealed from, to submit a copy of the order to the special referee's office. And at the 4-day hearing before the referee, she offered no testimony and presented no admissible evidence. Her public policy argument remains unavailing, as this court has already distinguished this case from Keller-Goldman, and the credit here has been applied at all times for both kids for their full benefit. If the court has no questions, I will rest on my brief.
Thank you. Toke versus 11 West 42nd, 11 West 42.
Good afternoon, Your Honors. May it please the Court, Michael Cassell for the plaintiff appellant Jeffrey Tolk. On our appeal, we raised 2 issues, one as to Labor Law 241-6 and also as to Labor Law 200. As a 241-6 claim, it's predicated upon Code Section 1.7d. As we set forth in our briefs, the specific language that we rely upon is the term passageways, which clearly applies to a staircase. The real issue here, and the lower court found erroneously, that the staircase where the accident occurred was not a passageway because it was too far from the actual floors that Mr. Tolk was working on.
I mean, there was testimony that this was the way that all of the workers got down to the basement to get the elevator that they had to take up to the floors they were working. And even though there was an elevator that went down stairs, apparently the testimony was it was so slow, it's just easier to walk down, and that's what they all did.
Exactly, and what you see, Your Honor, is the one case the court relied upon, which is 18 years ago. You see a nice transition from, especially this court, we have the Potenzo case, which is, of course, an outside accident, but within the security booth. That's the key. You check in the security booth, you're on your way to the work site.
Is there any other evidence that this was the general way that everyone used, the general staircase that everyone used?
Well, yes, as to workers, no as to the public. The public was to use the lobby of the building.
I'm talking about the workers. The workers I'm talking about. This was the case that the majority of the workers used was this staircase.
Not the majority, all of the workers.
All of the workers.
They had to check in.
Okay, so my question is there any other testimony but that? Is that contradicted in any way?
It is not contradicted. Thank you. I don't really have anything else on 241. Just to note also, the Hoyos case also, which is a Labor Law 240, open paren, close paren 1 case, which was also an accident under similar circumstances. The plaintiff is standing on the loading dock, falls off the loading dock, and this court understandably found that that loading dock is part of the work site, even though the plaintiff had to go up in the building to work. So the recent case laws under the labor law have all found under this situation, at least in this department, that 1.7D and 241-6 applies. Briefly, as to the 200 claim, I think I heard the last oral argument. I guess I would like to distinguish what we have here is on the summary judgment standard, the burden would be on the defendant, CJS, to show as a matter of law it had no notice of the water on the stairs. There was no inspection done by CJS. In fact, there was some testimony that CJS at times had laborers in the area and at times would clean the stairs if need be. So at least at the summary judgment stage, CJS has not sustained its burden of proof as to the 200 claim. Certainly at trial, we recognize that Toke would have the responsibility to demonstrate notice to win, but at the summary judgment stage, there was a question of fact, and summary judgment should have been denied. Thank you.
Thank you.
May it please the court, my name is Michael Kazores on behalf of CJS. We believe that the lower court got it correct that this was not a passageway because he was not injured in a work area, but a common area of the building that was remote from where the
How is
the
that,
work was
but
being
really,
done.
how does that make sense? That they were required
No,
to check in. They were required to check in and then to go to the basement.
They were required to check in with building security.
Yes, and then they had to go to the basement, didn't they?
Yes, and they had 2 ways to go.
Right, and so you want all those guys who are on a clock to sit there and wait for a really slow elevator to go down one floor. That's what you're suggesting would be what the workers would do? They were all in line that morning to take the stairs down. The testimony was that was how they did it.
That was how most of them did it. That was
That's
the plaintiff's testimony. My client testified that he was not even aware of that these were these stairs and that all the workers took the freight elevator. And
But
after
how did
plaintiff
he
came
know
back,
if all the workers said that they took the stairs? And as a matter of fact, I thought the testimony was that Mr. Toke was the first in line. It was 7 o'clock in the morning. They were just starting their shift, and there were a bunch of workers, and that's how some of the other workers happened to witness the accident, because Mr. Toke happened, unfortunately for Mr. Toke, be the first one in line, and he's the one that slipped, and the rest.
he was the first one. After he was injured, he came back to work and he used the freight elevator.
But counsel, you also have the testimony of the property manager, I believe it was Ms. Rothman, who also indicated that the workers, they were first required to enter the loading dock and then access the basement by either the freight elevator, which we know is slow, the workers don't use it, or the metal stairs.
Right, they had one of those 2 options to use. And under the O'Haty case that this court decided last year, said a staircase used to provide access to a job site is not a passageway or other working surface within the meaning of the provision.
Except that we have cases in the first department that says a staircase is a passageway, so.
I'm sorry?
We have cases in the first department that says a stairway is a passageway.
Right, unless it's only if it's the sole means of access.
Yes, but in this case, it essentially is the means by which everybody uses. I mean, it's essentially
It wasn't the sole means of access.
So why is being sole means of access, what has that got to do with whether or not it's a passageway? There's nothing in the statute that says that, right?
Well, that's what
And that's
this court
something-
decided.
And our cases have said, sure, look, he had to get, this is a way he or she had to get down there. But are you hanging your hat on the fact that there was an elevator? That is why this isn't a passageway?
Because it wasn't the sole means of access, and that's what this court held last year in the O'Haty case.
Well, how about Potenza?
Potenza was different because they had to sign into a gate and they were already in the work area.
No, Potenza is exactly like this case, except it's a pathway and not a stairway. They were required to sign in at a place that was right next. The stairway here is not somewhere far and remote from where they signed in.
I think there's a distinction because once they signed in, they were within the work area in Potenza. Here, they had to go down the steps.
No, actually, I don't think that there was testimony that they were within the work area. They still had to get into the building, and there were 2 different paths. One they'd have to go all the way around for, just like here. The one that the management said they should use was all the way outside and back around. This one is going to someplace where they would be standing there. So effectively, this was the sole means.
Do your honors want to hear my argument on the 200 in common law? The building.
I'll give you 30 seconds.
Sure. The building testified that it was responsible for cleaning these stairs. In terms of notice, the plaintiff himself testified that it was a building maintenance worker that caused the condition moments before the accident occurred. He even had a discussion with the building worker and the building worker's boss, and they both apologized for causing the condition. So in terms of causation, CGS didn't cause that. The building also testified that they were fully responsible for maintaining and cleaning the area. CGS had no responsibility and no authority to police that area, so we can't be charged with actual or constructive notice. Thank you.
Thank you. Thank you both. Oh, I'm sorry. You have rebuttal, don't you? 1 minute.
No, and I just want to ask you, you agree that the plaintiff himself testified that it was the maintenance worker that was mopping up, that made the mess that he fell on, correct? correct?
Yes, of course.
So I don't know how you can say, if they put in that testimony, how do they not meet their 200 burden?
We argue that the standards at summary judgment at least would be for defendant CJS to show the opposite, to show a lack of notice. There was some testimony that they could have labor stationed in the area. That's that issue.
But if the testimony is that the condition occurred a couple of minutes before, isn't that showing a lack of notice?
Well, there's no testimony from CJS as to whether they were there or not at the time. I will acknowledge, obviously, our 241-6 argument is much stronger than the 200 argument.
Fair enough.
Thank you.
Thank you. Thank you both. Dickerson versus New York State Division of Licensing. Reverend Dickerson, I'd like to explain the procedure. You have 4 minutes, and then counsel will have 4 minutes, and then you will have 1 minute of rebuttal. So in your 4 minutes, you should tell us why you believe that the decision below was incorrect.
Thank you, Your Honors. Good afternoon, Your Honors. May it please the court. My name is Reverend Robert L. Dickerson, and I'd like to read my arguments pretty brief. Your Honors, I humbly and respectfully beseech this honorable court to reverse respondent's decision denying my application for licensure as a private investigator. Notwithstanding respondent's arguments to the contrary, the administrative law judge and assistant secretary of state both erred in their decision to deny my application for a private investigator license, as the decision is a clear and an unambiguous violation of law pursuant to Title 19 of the New York Code Rules and Regulations, Section 413, subsection B, regarding time periods on submitted applications for licensing. Title 19 of the New York Code Rules and Regulations states as follows: with respect to applications for a license or a commission, the Secretary of State shall grant or deny such application within 150 days of the date of the submission of the completed application. The Assistant Secretary of State knew or should have known that they were in complete violation of their own rules and regulations concerning time restraints, which is a blatant abuse of discretion, arbitrary and capricious, and decisions should be reversed in the interest of substantial justice. My private investigator license application was received by the New York State Department of State, which is the respondent, on September 30th, 2017. Respondent violated their own mandatory rules and regulations by denying my application through written notice on July 12th, 2018, some almost 300 days later. Case law that's in this matter is in the matter of John F. Buck versus Respondent, Department of State, Division of Licensing Services, in the states in part. Respondent is bound by its own rules and regulations, including its procedural rules. In addition to the foregoing, Respondent violated my due process rights by failing to give me notification of a consumer complaint logged against me, which was received by Respondent on October 31st, 2016. Or rather, Respondent chose to irresponsibly make notification upon my filing for a private investigator license more than a year later. I respectfully request that for this and the reasons stated in my brief, that you reverse their decision and grant my application for a private investigator license. And if you have any questions, I'll be willing to answer any question you may have for me.
Thank you, sir.
Good afternoon. I'm David Lawrence III. I'm an Assistant Solicitor General appearing on behalf of New York State Department of State. I first want to address 2 points that the petitioner made in his oral argument. First is he raised an argument that he had not administratively reserved, that he had not raised in his Article 78 petition, and in fact did not raise until the first time in his reply brief in this court, and that is that the decision denying his license application was allegedly untimely under a Department of State regulation. As this court recently held in the matter of Wilner versus New York Department of State, that regulation is directory and it's not mandatory. Therefore, in order for somebody to get relief for an alleged violation of that regulation, they have to show substantial prejudice from the alleged untimeliness, and the petitioner makes no such showing here. Petitioner also argues that he should have received notification of the Ms. Long's complaint, his client's complaint, at the time that it was made. But at that time, petitioner had no private investigator's license. Therefore, the Department of State properly put this complaint on hold until such time as he again applied for a license. When he did apply for a license, the department's investigator notified him of the complaint, gave petitioner an ample opportunity to respond to the complaint, wrote 2 letters to the petitioner, also interviewed the petitioner twice by phone, and so petitioner was not in any way prejudiced by the alleged delay in informing him of the client's complaint. In any event, substantial evidence supports the determination denying the petitioner's application for the private investigator's license. Whereas I discussed in my brief, he failed to pay 2 tax warrants for over a decade, and the administrative record shows that he did not make any effort to settle those tax warrants with the State Department of Taxation and Finance until after the unpaid tax warrants were discovered by the Department of State's investigator. At that point, the petitioner finally, after over a decade, made efforts to settle those tax warrants. Furthermore, the petitioner failed for over 2 years to pay to his client $1,400 that the client had given to the petitioner for him to hire a forensic investigator. Once it became clear that the forensic investigator could not be hired because the petitioner did not have the information he needed to do so, the petitioner had an obligation then to repay the $1,400 and was not entitled to hang on to that money. Petitioner also failed to provide his client with a written report of his services. That report was due at the latest at the time that the client terminated petitioner's private investigator services. In addition, the petitioner provided private investigator services while he was not licensed to do so. His license expired on June 29th, 2016. After that time, petitioner interviewed.
Petitioner, I think, said that when his license expired, he thought he filled it out and he sent in the bond, but he didn't send in the application or something to that effect.
Yes, Your Honor.
Did the Department of State receive the bond?
I don't believe there's anything in the record as to that, but taking as true his testimony that he sent in the bond, we'll assume that the department received the bond. That obviously did not constitute an application. It did not have the effect of...
Well, it's not an application, but it does shed some credibility on his indication that he just got confused and sent in one and not the other.
Well, yes, he did testify that he sent in one without the other, but he did not seek at the administrative hearing in any meaningful way to attribute that confusion to his illness, which he later did. In this court, he testified at the administrative hearing that he was only having slight symptoms of his illness at that time. And in any event, when one has submitted a surety bond, that does not create any reasonable expectation in one's mind that one has submitted an application and that one may continue to provide private investigator services. I see that my time has expired. Unless the court has any further questions, I ask that the court confirm the determination, deny the petition, and dismiss the proceeding. Thank you.
Thank you. Yes. Now, you have 1 minute to challenge anything that was said.
Is it possible I could get 2 minutes, Your Honor, if I may?
Why don't you start with 1?
Okay. First of all, regarding my taxes, what the respondent is saying is blatantly false. I started negotiating for my taxes long before I even filed for a private
It was 10 years, wasn't it?
It was. But as you recall, Your Honor, in 10 years ago, in 2008, 2009, every person in America was experiencing some sort of financial calamity. Mine, I was not exempt from that. And I disputed for many years those taxes that the state was charging me. Finally, just before actually I went into the hospital with my 2 brain tumors, I was able to start a negotiation process with the state to try to mitigate those taxes because I just disputed them outright. When the Department of State contacted me about those taxes, I informed them, yes, I'm aware of the taxes. As a matter of fact, I'm in the process of negotiating it and to litigate it. And then I got the settlement long before I even had the tribunal hearing, long before that. So his assertion that I just arbitrarily decided to settle the taxes as soon as I discovered it takes years, Your Honor, to settle a tax debt with the state of New York. I don't know if you are aware of that, but it does. And in terms of me being unlicensed, as far as I stand corrected, he said I didn't hand a report over. I was unlicensed at the time. You have to be a licensed investigator to even write a report, okay? For the state or for the respondent to say that I didn't turn in something that I was not even legally obligated to do or even able to do is absurd. I couldn't write a report because Ms. Long terminated my services in October of 2016. My license expired in June of 2016. So I could not even write a report, even, and a respondent knows that, that I couldn't even give a report. So everything that he's asserting is blatantly false, blatantly false.
Thank you. And I gave you your 2 minutes.
Thank you so much.
Thank you. Thank you both.
Thank you.
Machester Villas versus Eli Development.
May it please the court, Brian Cowman, London Fisher, for the appellant. It is uncontested that the plaintiff did not seek a default judgment against the non-appearing parties. It is uncontested that at a PC, when I was representing another party, we asked, can we file an answer? The answer is no. It is uncontested based on the affidavit of Michael Slotnick that the court at that time told the plaintiff, if you're going to move for a default judgment, move.
What
It
about
put us
all
in a
the
precarious
adjournments
position
they
at
gave
that
you,
time.
counsel?
Excuse me?
What about all the adjournments they gave you?
I was grateful for that, and I asked for one more because we resolved an insurance coverage issue that we decided. I couldn't represent them. You're 100% correct. When we asked for the last one, the answer was no. We asked, we didn't get it. So we're not taking the default judgment from the date of the extensions. We're taking it from the PC order where the court said, if you're going to move for a default, do it. We make the motion 19 months later, 21 months later, my math is off maybe by a month, but it's over a year. At that time, we argued before the court, because now we have all the uncontested things. We argued before the court, there's no excuse. They said, well, we're litigating against Shelter Rock. They say we're litigating against Caliendo. We're asking for discovery from them. They're not giving us enough discovery. We can't give what we don't have. However, at that point, that's not an excuse. Under Zayas, there's a doctor, the Zayas case.
Counsel,
Yes.
aren't you telling them we're still trying to figure this out with
Not at that point. Not at that point. I asked, my associate asked, and Michael Slotnick sent an affidavit at
When did you tell them that there was no dispute anymore between you and your between the insurance company?
At the latest, at the PC in May of 2018. I know that because I was on trial and sent an associate to that part. and was fuming that nobody would give me that courtesy at that point when we were trying to work it out. We tried to work it out. The answer was no. That's why I got the affidavit. It's in the PC order that says we can move. We have the right to vacate the default. I'm fuming at this point. Still, nobody wants to give me the extension of time
But you know that they're litigating the case. It's not like you
against
have
the other
any
parties.
idea.
However, if you go to, as we cite, I'm not denying that, but you have to treat the parties different. Mutual benefits of offshore fund against Zeltzer, 172 AD 3rd
You have to
648.
treat them different, but there's a relationship amongst all these parties. I mean, it's not like they have nothing to do with each other.
I understand that, but when somebody, I understand, but the case law says if you don't take a default against them, Shelter Rock is still in the case. There's no ifs, ands, or buts.
No, what the case law says is if you show cause, then it's okay. So what I think.
There was no reasonable excuse articulated at the trial court level, except that we're litigating against different parties. We cited the case law that
Related parties, the same party, the same principles, right? So the whole situation is there's an insurance dispute. You've asked for and received a number of adjournments. They're litigating against your other parties. Clear to everyone that they're not abandoning this action, right?
correct against Shelter Rock. But when they lost that argument, when they say at the PC, no, you can't answer, they affirmatively did that. That's unrebutted. We have the affidavit of what was said. What's missing is the attorney from the plaintiffs to say, no, that's not true. I actually would have accepted the answer, but that's not there. What's there is, I was angry that day, and she still wouldn't do it. She wanted to hold us in default. She wanted to take advantage of an insurance situation, but then she forgot to take the motion against us.
Thank
so
you.
she used it as a sword and then forgot.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Michael Corcoran, Bronx Legal Services for the plaintiff respondents. This appeal arises from an order of the Supreme Court denying defendant appellant's motion to dismiss pursuant to 3215, finding that the plaintiffs had shown sufficient cause for not moving for a default judgment. I would first argue that this appeal was mooted when the defendant appellants voluntarily filed an answer on January 24th.
Well, no, but in their answer, counsel, didn't they say in their answer, we are not properly here? Because
They say in their answer that
it's not moot. They asserted the defense that they later moved on.
They say that they were directed on January 6, 2020 to file an answer. There is nothing in the record that supports that assertion.
I'm talking about, didn't they plead as a defense that this action should be dismissed as abandoned because you didn't move within a year?
And they said that they're only
there's
putting
not-
in an
that
answer.
doesn't- So then, one second, let me just
Sorry.
get this out. And that's okay, I mean, we're trying to both talk at the same time. Doesn't that show that this isn't moot, that they asserted that defense when they answered?
You can't.
And then they moved on it, which is
By
exactly what
filing
you're
the
supposed
answer,
to
they
do.
waive their ability to say that they're not participating, that 3215 can apply. They also put in the answer. It's a misrepresentation of the record. If you read the transcript, there is nothing in the transcript from oral argument on January 6th that in any way suggests that the court ordered them to put in an answer. They could
what I
tell that
wanna
they
know
had
is why
unpersuasive
didn't you
arguments.
move?
The judge asked plaintiffs, asked you if there was a problem on your part accepting an answer, and you said no problem.
And we said no.
It wasn't a direction, but it was.
Right, and everything in the record, every single time they've asked for an extension of time to put in an answer.
You were giving it to them.
We've given it to them. We've never denied it. At a preliminary conference order that the non-appearing defendants really shouldn't have had any role in, they sought to put in an answer, but they didn't even have an answer in hand. And
Can
so-
I ask you, counsel, why didn't you just move for the default?
Why didn't? Because it's of no benefit to us in doing that. They would have screamed bloody murder. The court would have allowed them to put in an answer. We wanted to adjudicate this case on the merits, and moving for a default judgment against them or not granting them the extensions that they requested wouldn't allow this case to be adjudicated on the merits.
Because you were litigating the case
Because
against
we
everybody
had
else.
not abandoned the case.
Right.
We had actively pursued discovery against other defendants. Counsel raises Zayas as something that's comparable, as well as Cruz and a few other cases. In those cases, there was no correspondence between the plaintiff and the defendant. Years had gone by. There was no, those cases could not be more easily distinguished. It's just, to rely on Zayas, which did overturn the Supreme Court's ruling, it's not supported by the underlying facts of the case. We granted every single request for an extension. We want to adjudicate this case on the merits. So for those reasons, I ask the court to affirm the lower court's decision.
Thank you.
Just briefly on Zayas, which I know Judge Renwick was on the case, that's with a doctor, a malpractice case with a doctor. The doctor was participating and performed the work at the hospital. To say there's no relationship between the parties, it depends, it's a degree of how related they are. There's a hospital that's granting credentials to a doctor. The plaintiff never moved against that doctor, litigated against the hospital. It's the same thing here. They're not even claiming that the developer put the hammers on the nails to make the building wrong. They're saying the GC. GC's in the case. It's the same thing. It's not that they're not going to have or be able to proceed.
I mean, I think the record, taken all in together, certainly shows that plaintiffs never intended to abandon their action, not just against Shelter Rock, but against you.
Against me, I'm not the party, but against those people or those entities, they lost their credibility on that argument was lost at the PC when they said, no, we're going to keep you in default. And you know what? That's really where I'm starting. I'm not starting any earlier for the default. They were told at that time, move for a default. They never did it. They wanted to use it as a sword. They lost the right. And I see my time is up. Thank you very much, Your Honor.
Thank you. Polaris Venture versus AD Venture Capital.
May it please the court, Michael Lynn from Arnold and Porter on behalf of the appellants. I know we're getting very late in the day. This is the last argument, so I'm going to get right to the point.
Well, we saved all our energy for you. Go ahead.
That's very nice of you, Justice Renwick. The motion court made two fundamental errors in this case. First, it failed to apply the correct legal standard under New York law for measuring damages for breach of a contract to deliver stock in a closely held corporation. This resulted in an enormous windfall for respondents. Second, the motion court made unwarranted assumptions on a disputed record, drawing inferences in favor of the moving party in derogation of the summary judgment standard. I'd like to focus first, Your Honors, on the legal standard for measuring breach of contract damages, because this contract was governed by New York law, and the motion court's decision has broad implications beyond this case for New York breach of contract law. As you know,
counsel, let me just ask you, what evidence did you put in to dispute that there would have been a second squeeze out?
So Your Honor, a couple of responses to that. We didn't have the burden of putting in any evidence. This was sort of proving a negative. Damages are measured on the date of breach. The only testimony that they put in was testimony given 7.5 years later about what might have happened. This was just speculation in our view, and doesn't detract from the fact.
Again, let me ask you, what evidence, assuming that, Justice Bark said, look, there would have been a squeeze out, it would have been combined, and the number that the Delaware court came up with would have been the number to value these extra shares. So my question again is, what evidence did you put in to dispute that?
We put in a lot of evidence, Your Honor, prior to the date of breach, which contradicted the evidence that they then put in after the date of breach. 7.5 years later, they had the controller, Bill Addy, who was my client's brother, testify about what he might have done. But
No. You have summary, so the question is damages.
yes,
You are disputing damages.
yes.
They say the damages are the amount that the Delaware court found that the shares were worth at the time of the squeeze out. And therefore, because if we had been able to get our shares, we would have put them up and we would have had that liability issue is gone. It's decided. You can't go back.
Right.
So again, my question to you is, what is the issue? What information have you put up
Okay.
with respect to damages?
Let me respond to that, Your Honor. First of all, under New York law, you measure damages as of the date of breach.
Is there any question that it's New York law, not Delaware law, that
No,
applies
Your
in
Honor.
this case, counsel?
Actually, the stock purchase agreement provides that it's governed by New York law without any conflict. But to answer your question, Justice Renwick, damages in New York for breach.
I think it was Justice
I've been over here asking those questions.
It gets hard. I do
Sorry.
have a question, but I'll
Looking very
it's I'll let you answer, then I'll have a question for you.
Okay. So in answer to your question, Your Honor, damages in New York are measured as of the date of breach. As of the date of breach, they did not have appraisal rights in these shares. So the only way they could have gotten appraisal rights was at some date after the breach. New York doesn't care about that because that brings in speculation, hindsight. You measure damages as of the date of breach, and as of the date of breach.
But wasn't there some question about what is exactly the date of breach in this particular scenario?
No, Your Honor. The date of breach was the date that my client failed to deliver the shares, which
The
was
March 13th
That's
date?
the date of breach. They have some testimony that at some point.
That's right, they do.
Right, days, weeks, we don't know when, and we don't know whether
That's not something that the court could consider?
It's speculation, Your Honor, but you also have to weigh that evidence, and a jury should have weighed that evidence against the evidence that existed prior to the date of breach, because ISN, the company, did not want people to put shares into the appraisal. They were very upset when they learned that my client had appraisal rights. In fact, they turned around and they sued their Delaware lawyers for $100 million for allowing my client to have appraisal rights, because the more shares that were in the appraisal could have bankrupted the company. They weren't interested in having more shares.
They wanted to squeeze out everybody, right?
Well, they wanted to keep my client in and squeeze out everybody else. That was their intention.
But okay, let's go back to the first question I think that was asked by my colleague, which was, what did you have that demonstrated that the second squeeze out wouldn't happen? I know that you're of the belief that they didn't come up with evidence as to why the second squeeze out would have occurred. But what did you have to disprove that a second squeeze out would have taken place?
Well, the only evidence, Your Honor, that a second squeeze-out would have taken place was the testimony of Bill Addy. There was no testimony given or any evidence at the time of...
Ryan Addy said that the second squeeze-out would have taken...
He was talking about...
Bill Addy, yes, Bill Addy, right.
My client,
yes.
he was talking
Right.
about a very different issue, which
Right.
was how do you value the shares at
Right.
that point. He wasn't saying that there was going to be a second squeeze-out. He was just saying that that was something that might be considered.
You mean when Bill Addy said that we would have done a second squeeze-out, he didn't mean that?
Well, he says it 7.5 years later, but look at the evidence that existed at the time, which is much closer to the date, and the evidence is exactly the opposite. He wasn't talking about a second squeeze-out. In fact, when he wrote to my client saying, if you transfer your shares to someone else, he wasn't offering them appraisal rights. He was offering them the merger consideration. He wasn't interested in having more people into this appraisal because of the concern that if it was a high award, it could bankrupt the company. So he wasn't interested.
How was he going to get rid of AdVenture or AD Venture then? Because they were not a suitable shareholder in an S Corp.
He could have at some point. They had been trying to buy, ISN had been trying to buy my client out for some time, but had been giving him very low-ball offers, Your Honor, and what my client wasn't interested. He really was trying to punish my client through this first merger by isolating him and telling him, if you ever try to sell your shares to someone else, at some point I might take them out, and they'll have to consider that because that'll decrease the value that they'll give you for your shares. That's what he was saying to them by his testimony. I see my time is up. I'll reserve
Okay.
my time for rebuttal. Thank you.
I don't know that you'll reserve, but you have 2 minutes, then I'll give you, you don't have any time less than that to reserve. Okay.
Thank you, Your Honor. Gerard Cedrone for the respondents. I'd like to address very directly the 2 main points that were raised on the other side's argument. First, the idea that it's speculative that these shares would have been appraised. And second, the argument that, that the breach is measured, or that the damages are measured as of the date of the breach. So first, as to the question of what evidence the other side has put into the record to show that these shares wouldn't have been appraised, the simple answer is none. Every piece of evidence in the record shows that had Adventure complied with its contractual obligations, these shares would have been appraised. And let me walk through briefly.
Would they have been appraised in the Chancery Court, though? No, right? In other words, they couldn't have been somehow added to the existing appraisal proceeding in the Chancery Court in Delaware, correct? These 76 option shares.
I disagree, Your Honor. I think there are 2 ways they could have been appraised. One is they could have been added into the existing appraisal proceeding. Bill Addy testified that he would have consented to their inclusion in the existing appraisal proceeding. It's no different from any other litigation when a defendant stipulates to a certain fact to streamline proceedings, and the other side hasn't pointed to anything in the record.
There's nothing in the contract that would have prevented that?
There's nothing in the contract, there's nothing in Delaware law, nothing that the other side...
But what about the court saying, no, I'm not doing it?
I think there's no indication in Delaware law that the court would have said no, and to the contrary, I think Delaware law shows that the court would have allowed that to happen. Delaware courts have the authority to manage their dockets. There's nothing in the statutory text of the provision of Delaware corporate law that prohibits it. And again, the opposing party, ISN, would have consented.
Well, what about the evidence that counsel is talking about that closer in time to the events at issue, the statements of your client? What about that? Why doesn't that raise an issue of fact?
It doesn't raise an issue of fact because the other side is reading only half of Bill Addy's statements. And so his most relevant testimony is at page 479 to 483 of the record. And what he said was that there was originally risk in cashing out everyone all at once, but as of the date of the breach, of these 900 shares that they were trying to get out of the hands of non-qualifying stockholders, all but these 76 were either cashed out or in the appraisal. At that point, there's no basis in common sense, let alone in the record, to conclude that Bill Addy and ISN would have left just these 76 shares dangling out there. I point the court in particular to his testimony at page 41 and 482, where he makes clear it wouldn't have made any business sense, and the suggestion that they saw risk in cashing out, or would have seen risk in cashing out these remaining shares, conflates 2 different time periods. The early January 2013 time period, when they were trying to put Adventure to the side, and the March time period, by which point Adventure had been swept up into this appraisal, and all of the shares were either cashed out or in the appraisal.
Are these issues...
I'm sorry, go ahead.
Are these issues that the judge should have decided on summary judgment rather than at a trial?
Yes, they are, Your Honor, because there's no genuine dispute based on the evidence in the record. So there is the testimony of Bill Addy, which we were just talking about.
Right.
It's unequivocal and uncontested. There's also the testimony of Brian Addy, twice, his deposition at page 256 of the record, and another declaration at page 1600 of the record, where he testifies that anyone looking to buy these shares as of the date of the breach would have understood that they would be cashed out. And he says it quite colorfully, but I think it shows that he's not mincing words. He says, the legion of doom will come down upon them. He, the defendant, makes clear that anyone looking at these shares at the time would have understood that they'd be squeezed out. And then there's also, in addition to that testimony in this litigation, there is contemporaneous evidence that we go through at pages 22 to 23 of our brief, which talks about board meeting minutes and other evidence explaining the purpose of this cash out and the fact that it was designed to get these 900 shares out of the hands of non-qualifying stockholders so that a conversion to an S corporation could take place. And so there's no...
Which didn't take place for a few years anyway, but...
That's true. It didn't take place for a few years, and there's testimony on that score in the record about the tax reasons for that. That's at page 483 of the record. The regular...
So you don't think that that is relevant to determining that they wouldn't have done the squeeze out or anything like that? The fact that they delayed so long to do the S corporation, you don't think that suggests that that's a reason why they wouldn't have done the squeeze out or weren't prepared to do it within the 3 months.
I don't, Your Honor. I think when you have Bill Addy's testimony, Brian Addy's testimony, the board meeting minutes, and importantly,
No,
nothing.
but except, counsel, isn't your argument that that was the reason why we had to get rid of those 76 shares to switch over to an S Corp?
It was. That's
And then there is that fact that that didn't happen for several years, which sort of undermines your argument that we would have done a second squeeze out right then and there so that we could right away convert, right?
I would emphasize two things, Your Honor. One is the concrete testimony of Bill Addy about timing when he's asked.
I agree with you, but the question really is just, do we need to have a trial, or is this a summary judgment issue? That's all I'm trying to say, and you're saying there's no evidence, but isn't the fact that you actually didn't convert for several years some evidence that that second squeeze out might not have happened, that the appraisal might not have been connected to the Delaware? I mean, maybe a trier of fact would say that's ridiculous. Of course it would. The question is, can we do that on summary judgment?
I think you can. I don't think that is enough to create a genuine dispute that would allow a rational fact finder to conclude that the appraisal wouldn't have happened. I would step back too and emphasize the common sense point that these 76 shares were a fraction of the 900 shares that they were trying to cash out, and an even smaller fraction of the overall shares. There's nothing in the record that Adventure points to that would allow a rational fact finder to conclude that in the face of all the rest of the shares being cashed out, just these 76 would have been left on the table. All they've offered is speculation and attorney argument. The last point I would make is getting to their second point about the date of the breach. The appraisal value that the Delaware courts determined was the value as of the date of the breach. It's not like cases where plaintiffs ask for an increase in value that happened after the contractual breach. Here we're asking for the value that existed on the date of the breach, which was the appraisal value. The reason we're here is that Adventure breached its contract with our client to deliver shares so that it could submit them to an appraisal and capture that value. The measure of damages is the appraisal value that we would have received. Thank you.
Your Honor, I wanted to address a couple of points that my opposing counsel made. He said initially that had they gotten the shares, they could have been put into the existing appraisal. And I think Justice, Your Honor.
Scarpula.
Yes, Scarpula.
She asked whether the court would have allowed it.
No, the answer is no. That would be a fraud on the Delaware court because they didn't have appraisal rights on that date. Only the record holder can seek appraisal for his shares. They're not transferable. They didn't have the appraisal rights, and if ISN and...
Except then we get back to the fact that, well, they could have done the second squeeze out and had them...
You're right, Your Honor. They could have done it in a year, in 6 months. We don't know when. It could have happened, but there's no evidence.
It could have happened immediately. Could have happened immediately.
Could have, but we don't, there's no evidence in the, well, it couldn't have happened immediately because you know under Delaware law it takes a month to publish a notice and then you have time to seek appraisal. It wouldn't have happened.
As immediately as possible under the
Yeah, but it wouldn't have happened for quite some time and there's no evidence in the record as to what the value of the company was at that date.
No, but all the evidence says that all the evidence submitted says there would have been a second squeeze out. And again, I'm going to ask you, what do you got that raises an issue of fact as to that issue?
Well, I think on that point, Your Honor, I think it's not all the evidence. There's evidence that suggests that they waited 2 years, as you said, to do this, to do the conversion. They could have easily waited, and a jury could find that Bill Addy, being a pretty wily guy, would have kept Polaris in the company for 2 years and tried to squeeze them and get a much better number than allowing them to do, allowing them to seek appraisal. That was his modus operandi with my client, and there's no reason to believe, and a jury could certainly find that he might have used his leverage to exact a much greater concession from Polaris. I also wanted to just briefly touch, I know my time's running out, but even, my time has run out.
I'll just give you 30 seconds.
Okay. I mean, we haven't talked about the knowledgeable investor rule, because I think even if you assume they had appraisal rights and the court was looking at it from that point of view, you still apply fair market value, but in that situation, you use the knowledgeable investor rule, which looks at how a knowledgeable investor, as of the date of breach, not 4 years later when the Delaware Supreme Court ultimately decided it, but looks at the date of breach, how would you have valued this company? Our client put in an expert report explaining how someone who's a knowledgeable investor would analyze it. They put in no evidence. That number was substantially lower than the $98,000 per share, and at least it creates a disputed issue of fact as to what the proper valuation should be for the shares. Thank you, Your Honor.
Thank you. Thank you both. And for